Good afternoon, ladies and gentlemen, and welcome to Oldham County Fiscal Court. I'm David Vogel, Judge Executive. We're happy to have all of you here for our meeting today. I'd ask you, if you have a cell phone with you, to please join me and turn it to off or vibrate so that it doesn't interrupt the meeting. If you're able, please stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'd like to ask our clerk, Tara Long, to please call the roll.
Magistrate Likens.
Here.
Magistrate Tice.
Here.
Magistrate Woosley.
Here.
Magistrate Jeffries.
Here.
Magistrate Hounds.
Here.
Magistrate Hawkins. Here. Magistrate Dye.
Present.
Magistrate Logston.
Here.
Judge Vogel.
Here. Having all members of the fiscal court present, this meeting is now in session. Is there a motion to accept the agenda?
So moved.
Second.
Are there any additions? I'd like to call your attention to, toward the end of the meeting, we're going to have two closed-door sessions. The wording of one of the first, or I guess the second item on the closed door there should be lead under KRS 61.810 subsection F, lead to the appointment of an individual employee. The rest of that wording can be restricted, please. Am I hearing no other changes? All in favor, please say aye.
Aye.
Motion carries. For those we have visitors here today, our tradition here is to read the minutes of our last meeting. It happens that between the prior meeting and this meeting, there was a special called meeting, so we have two sets of minutes to read. It won't take too long. I'll ask Tara to go forward.
September 19th, 2023. The Oldham County Fiscal Court convened at 2:03 p.m. with Judge Vogel, County Attorney Barry Baxter, and the following magistrates in attendance: Likens, Tice, Woosley, Jeffries, Hounds, Hawkins, Dye, and Logston. Motion was made by Magistrate Dye and seconded by Magistrate Woosley to approve the agenda with the addition of the closed session pursuant KRS 61.810F, discussions or hearings which might lead to the appointment, discipline, or dismissal of an individual employee, member, or student, with or without restricting that employee's member or student's right to a public hearing if requested. Motion carried unanimously. A moment of silence was held for Jake Luxemberger. Motion made by Magistrate Hounds and seconded by Magistrate Dye to approve the minutes of September 5th with the addition of the language "to surplus" in the surplus vehicle motion on page 512. Motion carried unanimously. During public comment, Rebecca Zocklein, Solid Waste and Recycling Coordinator, shared information about the waste tire recycling event to be held on September 21st, 22nd, and 23rd. The North Oldham Fire Protection District Budget and Tax Presentation. Chief Hewitt Brown presented information related to the fiscal year 23-24 budget and the ad valorem tax rates, which will increase to the rate of 9.5 cents per $100 value on real and personal property, 9.5 cents per $100 value on motor vehicles and watercraft. Discussion followed. Extension Budget and Tax Presentation. Ken Hepperman, Chairman of the Extension Board, presented information related to the fiscal year 23-24 budget and the ad valorem tax rates. Real property will be taxed at the rate of 1.4 cents per $100 value. Personal property will be taxed at the rate of 1.43 cents per $100 value. Motor vehicles and watercraft will be taxed at the rate of 1.5 cents per $100 value. And inventory will be taxed at a rate of 1.43 cents per $100 value. Extension agents presented updates on extension programming and events. Discussion followed. Westport Fire Protection District Budget and Tax Presentation. Tom Grace, the board chairperson, presented information related to fiscal year 23-24 budget and the ad valorem tax rates, which remain at the same rate of 10 cents per $100 value on real and personal property, 10 cents per $100 value on motor vehicles, watercraft, and aircraft, and 10 cents per $100 value on inventory. Discussion followed. County Clerk Amy Alvey presented Oldham County Fiscal Court with $114,640 I'm going to start over, $114,659.09 for excess fees collected in 2022 and updated the court on the county's election plans and options. Announced that October 10th is the last day to register to vote. Motion was made by Judge Vogel and seconded by Magistrate Woosley to take a short recess. Motion carried unanimously. Motion made by Magistrate Hawkins and seconded by Magistrate Hounds to resume the meeting. Motion carried unanimously. Motion was made by Magistrate Hounds and seconded by Magistrate Logston to approve the payment of the payables as submitted. Discussion followed. Motion carried unanimously. Motion made by Magistrate Hounds and seconded by Magistrate Logston to surplus a 2014 Ford Explorer and to list the surplus vehicle on govdeals.com as submitted. Discussion followed. Motion carried unanimously. Brian Fogel, Assistant Director of Planning and Development, presented the first reading of Ordinance KOC 23-920-343, repealing and replacing Section 250-050 of the existing Oldham County Comprehensive Zoning Ordinance. The second reading and public hearing is scheduled for October 3rd. Discussion followed. Motion made by Magistrate Hawkins and seconded by Magistrate Jeffries to authorize Judge Vogel to sign the litter abatement grant application and accept the grant if awarded as submitted. Discussion followed. Motion carried unanimously. Motion made by Magistrate Hounds and seconded by Magistrate Woosley to hire Hannah Pittman as building monitor for Parks and Rec at $10 an hour effective September 20th. Motion carried unanimously. Dispatch. Motion made by Magistrate Hounds and seconded by Magistrate Woosley to hire Patty Sanchez as telecommunicator 2, 5-year lateral at $28.24 an hour effective October 2nd. Motion carried unanimously. Police. Motion made by Magistrate Hounds and seconded by Magistrate Woosley to hire Evan Harrod as school resource officer at $32.70 base hourly rate effective September 20th. Motion carried unanimously. Motion made by Magistrate Hawkins and seconded by Magistrate Jeffries to enter into closed session pursuant KRS 61.810B, deliberation on the future acquisition or sale of real property by a public agency with the addition of the following people: County Attorney Barry Baxter and Deputy Judge Kevin Nuss, with Sheriff Tim Wakefield, Chief Greg Smith, and Barry Laws if needed, and KRS 61.810F, discussions or hearings which might lead to the appointment, discipline of an individual employee, member, or student with or without restricting the employee, member, or student's right to a public hearing if requested with the addition of the following people: County Attorney Barry Baxter, Deputy Judge Kevin Nuss. Motion carried unanimously. Motion made by Magistrate Hounds and seconded by Magistrate Woosley to come out of closed session. Motion carried unanimously. Motion made by Judge Vogel and seconded by Magistrate Woosley to appoint Jeff Dowd to the Library Board with a term to expire October 1st, 2027. Motion made by Magistrate Hawkins to table the appointment. Motion failed due to lack of second. County Attorney Barry Baxter issued a statement based on the limited information provided to him during the meeting that according to the portion of the statute provided to him, the fiscal court does not vote on this library board appointment. It is a decision to be made by the judge executive. The county attorney stated that additional research may be needed on this topic to be certain. Judge Vogel appointed Jeff Dowd to the library board with the term to expire October 1st, 2027. Judge Vogel reappointed Michael Plumley to the library board with a term to expire October 1st, 2027. Discussion followed. Motion made by Magistrate Likens and seconded by Magistrate Woosley to appoint Panita Bradley to the ambulance taxing board with a term to expire September 19th, 2025. Motion carried 6-0 to 3. Magistrates Logston, Dye, and Hawkins abstained.
You've heard the reading of our minutes
I'm
from...
not finished.
You're not?
No. Motion made by Magistrate Dye and seconded by Magistrate Jeffries to adjourn the meeting. Motion carried unanimously, and the meeting adjourned at 6:11 p.m.
Judge, I'll move that we approve those first set of minutes.
All right, thank
Second.
you. Second? Second. All in favor, please say aye.
Aye.
Motion carries. I want to make a note that the discussion about the motion that we just read about maybe leading to the appointment or dismissal or so forth of an individual, no action was taken in that closed-door session that we had. All right, now the September 22nd or 27th meeting.
September 27th, 2023, the Oldham County Fiscal Court convened for a special meeting at 11:02 a.m. with Judge David Vogel, County Attorney Barry Baxter, and the following magistrates in attendance: Likens, Tice, Woosley, Jeffries, Hounds, Hawkins, Dye, and Logston. Motion made by Magistrate Dye and seconded by Magistrate Woosley to approve the agenda. Motion carried unanimously. Public comment, Rebecca Zoklin, Solid Waste and Recycling Coordinator, shared information about the Household Hazardous Waste Collection event that will be held on October 7th from 9 a.m. to 3 p.m. at the Oldham County Road Department. Advised that additional traffic may be encountered in the morning hours due to the games at YMCA. Motion made by Magistrate Diane, seconded by Magistrate Woosley to authorize Judge Vogel to sign the MOU Ballardsville as submitted. Discussion followed. Motion made by Magistrate Woosley to call for question. Motion carried on a roll call vote of 8-1. Magistrate Hawkins voted no. The original motion carried unanimously on a roll call vote. Motion made by Magistrate Diane, seconded by Magistrate Woosley to authorize Judge Vogel to sign the Motorola Ballardsville contract as submitted. Discussion followed. Motion carried unanimously. Magistrate Dye left the meeting at 12:06 p.m. Magistrate Dye returned to the meeting at 12:08 p.m. Tina Schaaf, Director of Human Resources, announced the resignation of Dale Rhodes, Emergency Management Director, effective October 1st. Motion made by Judge Vogel and seconded by Magistrate Woosley to appoint Jeff Dowd to the Library Board with a term to expire October 1st, 2027. Discussion followed. Motion carried unanimously. Motion made by Judge Vogel and seconded by Magistrate Jeffries to reappoint Michael Plumley to the Library Board with a term to expire October 1st, 2027. Motion carried unanimously. Motion made by Magistrate Jeffries and seconded by Magistrate Dye to adjourn the meeting. Motion carried unanimously, and the meeting adjourned at 12:33 p.m.
You've heard the reading of the minutes from September 27th. Are there any corrections?
Make a motion, we approve the minutes.
Second.
All right. We will change where it says contract resolutions MOU at Ballardsville. That should say in Ballardsville Fire Department. And regarding the Motorola Communications contract. Okay. Got a motion and second. All in favor, please say aye.
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 Motion carried. Anybody object? Motion carries. Thank you. Okay, time now for public comment. That's the time during our meeting when anyone who would like to address the fiscal court about a community issue is able to do so. If you've come to speak regarding something that's on the agenda later, we ask you to hold your comments until that time. All right, Becky, go ahead. Becky Zockline.
Thank you, Judge. Rebecca Zockline. There, got it. Rebecca Zockline, Oldham County Solid Waste and Recycling Coordinator. Once again, I'm coming before you to remind everyone of our Household Hazardous Waste Collection event this coming Saturday at the Oldham County Road Department. This again, I'm emphasizing this is a new location, but it is also our permanent location. I've become aware that there will be a huge amount of traffic on that same day in the Buckner area, particularly on 393. So I'm strongly suggesting that people approach the road department site from the west. So if you're coming from, or try to find a way to divert around or away from the Buckner area or that Buckner intersection at 393. So I suggest either using exit 17 off of I-71 or using the new, the Commerce Parkway extension, emptying out onto Mattingly Lane, and you should be fine. So, any questions?
Anyone?
Wait just a minute, let's see.
All right, thank you, Becky.
Thank you.
Is there anyone else who would like to address public comment here? All right, seeing no one, I'll close the public comment and go on to the next item on the agenda here today. We're just, I believe, a very short time away from the exciting opening of a new Kroger store in Oldham County, and Sandy Hensley is here from the Chamber of Commerce to introduce Kroger guests.
Good afternoon, everybody. I'm Sandy Hamilton, Vice President of Economic Development for the Oldham Chamber and Economic Development. It's okay.
Huh?
That's all right.
Well, it's all right. Well,
No worries. The past several months, our office has had the opportunity to get to know and work with the Kroger team that is going to be responsible for managing and operating the new Kroger at Exit 18. So the last presentation that Lynn gave to us was pretty impressive. I think you'll enjoy learning about the store and most importantly, appreciating his passion for what he does in the Kroger organization. So I'm going to introduce you to Lynn Rummage. And, I'm sorry, lane rummage, I'm doing what this. But this is Lane, and he's going to tell us a little bit about Kroger.
Thank you so much. And thank you all so much for the invite today. This is a pretty special moment for us all, really. You think about our company, this is in our division, right? So we have right about 114 stores in our division, and this is the first net new store in a new community in almost 15 years. So for that to be right here, and then for them to ask myself and Chris, our other guest, that'll be a manager there with me also, to come open the store up has been pretty neat. And then getting to see the community and really, work in partnership with some of the schools and the Chamber of Commerce and Economic Development, just get to meet people here has been very, very special to us. So I really do appreciate you guys. The store is, as you can see from the outside of it, it's pretty nice. It's big. It's the fuel island that's in front of it is actually one of our largest fuel islands that we have in the division, and thank goodness it's open and running. So we've got that up off the ground and soon to open the store. But the store is something we call a prototype store. And it sounds maybe more complicated than what it is. It's still selling groceries out of a grocery store. But you think about the way it lays out, there's no other store in our division built like this. And in fact, my DM and my district manager and I had to fly to Arizona, where they're building some stores at a pretty fast clip. We had to fly out there to see how one of these stores lays out, how it operates, how it shops, how it merchandises, all the little pieces that you don't think about when it's just groceries to the shelf. But the way this store lays out is not like anything else you will have shopped around here. And, it's really, from the front, you notice it's one in and one out, typically in our traditional stores that you've seen here, especially on that size. So the store's just over 106,000 square feet of traditional grocery. And, typically when we have a store that large, you think of a main entrance and a secondary entrance. And here the store is truly set up for one in, and it flows, and then the one out to really help with that shopping experience. As you walk in the front door, you'll notice, it's totally different from the start. So you'll come in the main foyer. There'll be the entrance there. There'll be a mural in the foyer that we've done in partnership to really commemorate Udell Gardens. You'll notice them, the mural that really takes after them. And then as you walk in, you'll see floral on the left. It greets you right as you're inside the front entrance, and a nice new Starbucks kiosk that's on the right. Looks totally different from any other Starbucks kiosk around here also, kind of fitting with the store, right? It's nice and open and big. And then really you walk straight into produce department. So the store is designed to be very fresh focused, and you'll feel that all the way through. So you've got the produce department, very large produce department, as you're walking through, and it'll flow you over into our bakery department and Murray's Cheese. And you'll notice that with bakery and our meat department, we call them being in the round. So they're actually on a large island out on their own rather than up against a perimeter wall like what you would traditionally see here. And so as you shop around produce, and Murray's there, and bakery and Murray's there, you'll see a large seating area. So we have a very large inside seating area right next to our Starbucks for the public to be able to come in, sit down, enjoy Starbucks, lunch, Wi-Fi, work from there, meet people there. The last store I'd been managing, we would have lots of businesses meet people there for interviews and just different, they use that area for different things. So it'll be a nice place for our public and our community to use. And then there'll also be an outdoor seating area, a patio seating area that you can access from the front there. And then as you flow around that corner, one of the things you'll notice is our deli is on the wall, but it really works with meat department and deli to create this fresh alley that really gives it a market feel. Totally different. You're not even thinking about dry groceries or anything different other than fresh food as you're shopping that part of the store. And then as you come out the back end of around meat, well, let's not downplay meat. So meat will have a nice, large, open-air seafood case, and then a 20-foot, which doesn't sound like much, but it's a 20-foot service meat shop, like the butcher shop case. And that's one of the largest you'll see in any of our stores around here. So really very, very fresh focused. And then as you turn the corner, you'll see probably the largest dairy department I've ever seen in my career. Very, very huge selection there. And then that takes you into dry grocery. And then it's still even different in dry grocery. We've set up, it's almost like a store within a store. So, you'll have all of the food together. And then as you come out of dry grocery food, on the other side of the store is set up for the non-food. So it makes it flow better. It makes more sense as you're shopping the store. So you're not shopping for light bulbs beside spaghetti sauce, right? And so it really makes sense as you shop the store and see how that lays out. And then it flows you up toward the front of the store where we'll have pharmacy, a little clinic. So for anybody who's been in the Prospect store or some of the other stores around, the little clinic it'll offer healthcare services to the community. And then we have a tenant space also in the front of the store, where there hasn't been anything signed there just yet, so we're still waiting to see who will fill that. They've got some people that they've talked to for that, but nothing nailed down that they've given me. And then, as you turn the front of the store, you'll notice we've got the front check lanes and self-checkouts, and then just nice lettering and artwork on the front wall, and it spells out Buckner very, very large on the front wall of the store. And you'll see Buckner at the beginning as you walk in the foyer, and then at the end as you walk out on the front wall. So truly a lot of pride in being able to come to this community and open that store finally since about 2005 when they bought the land. And,
Been working on it for a while.
a long time coming, right? So it's very special. And, it's almost a case of, good things come as we wait, right? Patience is proven to give us a really, really nice store. And really a best-in-class store as you compare it to any other stores around here, Kroger or otherwise. So we'll open up with roughly 270 associates, which is over target. So I was given the direction to overhire for the store and give us some room to grow. And so that's what we went and achieved. And, thank goodness we've been blessed with lots of great applicants to come work at our new store. We're fully staffed now. Now there's likely changes between now and when we open, but for the most part, fully staffed at the store, which is a blessing. About 85% of those associates are new associates to the Kroger family. So that's really great news when you think about creating jobs in the community. And then we have several department leaders that will be from the community and outside the community. But about half live here also, so that's a really great piece for us. And then the team, so I've been managing stores I've been a store leader, a store manager for Kroger for 8 years now, going on 9 years. And a big piece of what we do is really focus on community. So my last store I was managing was the one in Bardstown, and we were very, very big. That's where I was born and raised, and so it was easy to get out and be engaged in the community. But as we've been hiring, as we've been having leadership meetings, as we've been doing things, that's very much our focus, is not just opening up shop and selling groceries, but truly finding a way to be a community partner. And I think if anybody's been around Oldham County High School, we've had several different events that we've done with them to partner, and just different things around town. So that's truly one of our goals, is to be a community partner and find ways to help with that. And then our last piece, so at about 12 o'clock, I was texting with our public relations person in our Louisville office, and she said that we can, I guess, make it official. So we look to grand open on November 1st. So very,
great.
very quick.
All right, that's great. I know your gas facility is open now, and
Yes, sir.
I believe we're going to sign the Spirit store liquor license, maybe today or tomorrow. I think it's on my desk. I'm not sure, but we'll get you going. You can get that open too if you like. And so I think the community's excited. Now, a question that comes up is what about the LaGrange store? What's the status of that going to be?
So it will. There's no danger to the LaGrange store. So as we've ran numbers, and the fuel centers actually helped us look into how is that going to somewhat affect. There's some ties to when we opened our fuel center to what it did to their fuel center. We believe there's some parallels there. And it was actually, if those numbers stay true, is actually less than what we budgeted to come out of that store. When you think of total business, we always look at business with sales without fuel, right? And so it was actually a smaller percent than what we saw, what we budgeted for when we grand opened the store. So still be a very busy store. The LaGrange store has been, it's been doing more business than what it was actually built for some time. And they will still be very profitable, very, very busy. So.
Right. Well, we're happy, pleased with the people that work there. I want to ask one more question.
Okay, sure.
Before you ask it, let me ask
Okay,
it.
all right.
Okay. I know you laid out the store. You gave us all a lot of details there. And you don't have to, I know that you're going to do what you need to do, but I'd sure like you to put the milk in the front.
So with the prototype store, all of these get laid out from Cincinnati, so they really study it. But maybe you let me know when you're coming. I'll bring it up front.
All right. Measure Jeffries.
Yes, sir, Lane.
Absolutely.
We're really excited to have you in the community or whatever, and looking forward. I think a lot of folks are looking forward to that November opening. One question I had that I've been getting is, what's the plans on any electric charging station for electric vehicles?
Certainly. So all of the infrastructure for that is in place now. So that way, and we've been working with LG&E to determine if we're going to go ahead and install those now, or if that's something that comes a little bit after opening. But either way, they've already ran all of the infrastructure from inside the store, underground, out to the parking lot, and there's a junction box out there for us to be able to, essentially plug and play, right? So it's a very simple process. Should we be able to go ahead with LG&E and get those installed? Now, again, so it's most of that's over my head. My understanding is there's 3 different types of charging stations, and this would be so. Stage 3 would be essentially what you have at home. Stage 2 would be better than that, but not supercharging like the Teslas or Stage 1. And right now we're in talks with LG&E for Stage 2. That would be installed on the kind of toward the 71 half of the parking lot on the front side. It wouldn't be all the way against the curb, but it would be on that side, kind of in front of the patio seating area.
Do you have any idea how many that you're going to be looking at to begin with?
They hadn't told me a number of units that it would be, no, sir.
Okay. And just one other question. I assume you'll have delivery available from that store, the Kroger delivery?
Absolutely. So delivery, we actually run out of, we call it a spoke. So we have fulfillment centers that we've built in partnership with a company called Ocado, and those are actually assembled, the dry grocery part, and then they have other drivers that will assemble the fresh perishable side of those deliveries and load those in the blue Kroger vans that we all see moving around. And then pickup we'll have, and it's actually, you can see it on the side of the building, painted in blue, and it's really nice to where, one of the good things about building a brand new store is everything's fitted how it should be, not having to fit into something that's been there. So, with it being around the side of the building, actually is very conducive to the ease of traffic and check-in and the speed that we can get those orders out to the car. Just makes it a much more convenient experience for everyone.
Thank you, sir.
Thank you.
Measure Woosley.
Mr. Rumledge, I understand McDonald's is also going to open at the same time, November 1st, or that's the plan?
The target is for them to be very close. I haven't heard that they're going to be able to hit the same date, but they want to be very close to our opening.
Okay.
Yes.
Do you have plans for traffic, for the expectation of extra traffic that first few weeks?
Yes, sir. So we're actually in the works on getting wayfinding signage to be able to have in the parking lot. And this was our construction meeting, our planning meeting yesterday. All of that's on order. And so this week we're working on stepping out. Where do we place those signs to be able to help people make it back out to Commerce and to 393 to 71. And then they're also working for, I believe they're installing a traffic light at the back side where the back entrance further away from 393. But there will be quite a bit of wayfinding signage ahead of us and McDonald's opening. Yes, sir.
Thank you.
All right, well, Mr. Rummage, thank you. Welcome to Oldham County, and we wish you the very best, and we'll look forward to being there on November 1st when the store opens. So-
And if you all would like, if we could work through, so Miss Sandy has my personal cell phone number. If you all would like to try to come through and see it ahead of November 1st, I would love to invite you all in to be able to see it.
All right, well,
Guys,
we'll
you
work
didn't-
with the chamber on that, and
This way.
maybe some of them, okay. Mr. Likens?
I want to know if you were going to use Kentucky Proud or local produce. Like to see our local economy grow.
Absolutely. So we're a very big proponent of Kentucky Proud. We have a huge representation of a lot of Kentucky Proud products in the store. But when we start to get into local produce, a lot of times we have different maybe perspectives of what local produce is. And so we do have a lot of partnerships in what's considered locally. But, like in Bardstown, when I say we have local produce, everybody thinking that, would think that it's coming from Nelson County or something like that. But our partnerships locally in produce typically come from like Granger County tomatoes. There's a huge pumpkin farm or watermelon and pumpkin farm in southern Indiana. And lots of different places that are able to produce to scale to sell in Kroger that are considered local. But it's a little bit different when we start thinking about local produce there's a certain mileage that it is from distribution to the shelf where it's considered local. But Kentucky Proud, we put on a big food show actually at our division office every year that gives local businesses the opportunity to come in and be able to showcase their product to the people in our division office, all the leadership in our division office, to be able to get that into the stores. So you will see quite a bit of representation of Kentucky Proud, I promise.
All right, again, thank you very much for being here, and I'll be in to get that gallon of milk. So
I'll bring it to you.
give Sandy your phone number because I'll be calling you.
She has it, yes, sir. Thank you all so much.
Thank you very much. All right, we'll move on with our agenda here today, and the next thing is our the fall paving projects, and I believe our county treasurer, Pat Mateo, has those.
Good afternoon.
Okay. This project, I guess, covers what? Number of,
Taylor Creek,
there's a lot of different places in this project, correct?
yes.
Okay, so I can't
paving list.
enumerate them all. I just give the number here. $1,427,972.91.
Who's the vendor?
What company?
Flynn Brothers.
Can you repeat the number again, Judge? I'm sorry.
Yeah, it's $1,427,972.91.
Thank you, Judge.
The next bidder on this is Hall Contracting. This is $1,351,188.30.
What was that again, Judge?
$1,351,188.30.
Was that one Hall?
This is Libs Paving, Floyd's Knobs, Indiana, $1,194,207.50. Is that it for that group? Here's Louisville Paving.
I don't know.
$1,282,887.71. Mac Construction, $1,355,400. Riverside Paving, $1,524,395. All right. Final number in this group is Wingham Paving, $1,239,895.12. All right, we've got, now we've got the Pee Wee Valley paving that we bid as well. This is for Pee Wee Valley, Flynn Brothers, $36,265.54. Libs Paving, $33,242. $33,242.
That can't be much asphalt. We're gonna do the mayor's driveway.
All these bids, of course, are sealed and not opened until you see it being opened now. It takes a minute to get them open. And we'll get a new letter opener here between now and the next meeting. I mean, a new piece of equipment, not a new person. I'm sure you would appreciate that. $47,500. This is Louisville Paving. $47,554.84.
How many cents, Judge? I'm sorry.
For 84 cents.
84. Great, thank you.
Okay, I think so. Here's Riverside Paving, $51,769.
That letter opener looked a lot sharper than I thought.
All right, final one for Pee Wee Valley is Wingham, $24,137.56. $24,137.56. All right, we'll give those to the engineering or treasurer. Thank you, Pat. Okay, thank you. Next item on the agenda, county administration. It's the bills that we pay every 2 weeks to keep our creditors at bay. So when you're ready, we'll go with that.
Judge, I just asked the county engineer, and he said he's going to try to come back today with the award.
All right, that'd be fine.
Make a motion to pay the bills.
Motion to pay the bills. Any questions? Hearing none, all in favor, please say aye.
Aye.
Anyone opposed? Motion carries. Time now for the second reading and the public hearing of our zoning ordinance amendment to section 250-050. I guess Jim Urban and Brian Fogel from the Planning Department will lead the court through that. This is going to be a public hearing so that we'll be giving an opportunity to anyone who would like to speak in favor of or in opposition of the change to the zoning map. Okay.
Good afternoon, Judge,
All right.
Magistrates. Jim Urban, Director of Planning and Development Services. With us today, Brian Fogel, Assistant Director, and also Ryan Fisher, Senior Planner. They're going to be part of the presentation. This is something that we've actually been working on for quite some time. We've gone through the Study Review Committee and the Planning Commission to make this recommendation to you all. Last month, you had your first reading, and Brian was here. So today, as you mentioned, Judge, this is a public hearing. So I'm going to turn it over to Brian.
Thank you, Jim. Brian Fogel, Assistant Director, Planning and Development Services. We did have your all's first reading at your meeting in September, and it's a proposal to repeal and replace the section of the zoning ordinance that addresses short-term rental properties. Kind of a quick explanation of how we got to here, because as Jim mentioned, this has been ongoing for some time. It's been under study since April of this year with lots of public input. And basically we got here because the zoning ordinance was updated in 2019. And since 2019, technology has changed to where we've had the introduction of hosting platforms such as Airbnb, VRBO, FlipKey, Home2Go, and a handful of others. And the changes that we're talking about in the zoning ordinance are basically something similar to Airbnb. We use the term short-term rental property, which is kind of analogous to using the term tissue, but everyone calls them a Kleenex. So, you know, you may hear people refer to Airbnb. Well, we're really talking about the short-term rentals. Because of the changes in the hospitality industry, with this type of business being internet-based, we're finding that it's introducing commercial activities in residential neighborhoods. And we've had a lot of concern with that, and that's why we took up the study and are before you all today with these proposed changes. Jim alluded to the fact this has been ongoing. The Study Review Committee met 4 times in April, May, June, and July. Public notice was given for all those meetings. We had a lot of participation from the people in attendance at those committee meetings, both proponents of the changes and then also opponents of the changes. At the July Study Review Committee, they did endorse a proposal that went before the Planning Commission on August 22nd. Public notice was given for that, like there is for every public hearing that the Planning Commission or you guys have. The Planning Commission heard that and unanimously recommended approval of the proposed changes to you all, the City of LaGrange, City of Pewee Valley, and City of Crestwood. And then you know that we were here on the 19th and we're here today for the second reading and public hearing. All right, so just a quick summary of what we have done in updating this ordinance. I'm going to go over the first couple items, and I'm going to hand it off to Ryan to go over the next 3, and then we'll just come back and kind of summarize things. We're going to go through this thoroughly, but as quickly as we can. If you guys have questions, ask. I will tell you probably a standard response based upon our experience with the Planning Commission is that I may be covering something and you'll ask a question, and I'm going to ask for your patience because a standard answer is probably going to be, it's in the ordinance, give us time to get to there just to kind of keep things moving forward here. So what we've done in updating the ordinance, we updated the definitions to reflect today's reality with this industry. We also updated where short-term rental properties are allowed and what the review process is to get approval for one. We changed our operating standards and requirements to address some of the concerns we were hearing from neighbors. We updated our registration process with short-term rental properties. And then we also spelled out when we have an issue where we've got an enforcement problem with the short-term rental property, what are the processes for us to deal with that? The first section that we're going to go over are the definitions. Now, what's on the screen from here forward is basically the exact copy of the ordinance that the Planning Commission approved. But in terms of explaining the ordinance, I'm going to jump around on the definitions, just because the very first definition that's most important is what is a short-term rental property, but alphabetically, it's not at the top of the list. But we will cover every definition. So a short-term rental property is a dwelling unit that is used and/or advertised for rent by transient occupancy in which no meals are served for a time period less than 30 days. Basically, that's the Airbnb model for something that's less than 30 days. And then we also have in that definition the fact that this particular definition does not supplant or replace any other type of businesses that have transient occupancies that are defined elsewhere in the zoning ordinance, such as bed and breakfasts, boarding houses, extended stay lodging, hotel, motels, and recreational vehicles. The next definition that we're going to go over are transient guests. In plain English, a transient guest is a person and/or their guest who have rented a short-term rental property and are entitled to occupy that for a period of time less than 30 days. Our next definition is host, and we've got two categories of hosts that we're going to go over, which are significant in terms of how we handle the short-term rentals in neighborhoods. So a host is any person who is the owner of record of the property who offers a short-term rental property for transient occupancy. And the first type of host that we have defined is a non-owner occupied host, who's an owner of record of a short-term rental property whose primary residence is not located on the same lot or an immediately adjacent lot of the proposed short-term rental. Conversely, the owner-occupied host is an owner of record of a short-term rental property whose primary residence is located on the same lot or an adjacent lot that's immediately adjacent to where their primary residence is. And I'm going to diverge just a little to give an explanation there. We found in working with the study review committee that this is an important consideration, that we have landowners and future landowners in Oldham County who may own large acreages that for whatever reason are divided up into different parcels. Well, if they live on one parcel of a farm, but a different part of their farm, which immediately adjoins that, is under their common ownership, in terms of this regulation, they would be defined as an owner-occupied host. And then just down at the bottom, a little bit to clarify some of the closing of loopholes that we wanted to make sure that we closed, it's in our existing ordinance, is that an owner-occupied host basically includes a person, a personal or family trust, a limited liability partnership, or limited liability company, all of which must consist of persons and not a business entity. And that business entity is significant as we get further into the ordinance, because what we're finding is that you have investment firms that are business entities that are purchasing property and looking to set up short-term rental properties. All right, our next definition is just that. I got ahead of myself. A business entity is a corporation, partnership, or other legal entity that is not a person or a personal or family trust.
I've read all this crap.
Primary residence is just what it says, and what we've done is we've put a time period in there. And when Ryan gets up and talks about the licensing requirement, that becomes significant. A primary residence is the main home of an individual where they reside a minimum of 6 months on an annual basis. A manager, which is very important, we're finding in the operation of these types of commercial activities, is an individual with a permanent address located within 25 miles, and we have it defined how we measure it, who is available 24 hours a day, 7 days a week for the purpose of in-person responses to complaints regarding the condition, operation, and/or conduct of transient guests of the short-term rental property. And we put the language in there is that there's an expectation that that manager is authorized on behalf of the host to undertake remedial action to address compliance, maintenance, and safety issues related to the operation of the short-term rental. Bedroom is an area of short-term rental property that's occupied for sleeping purposes and in compliance with the Kentucky Building Code. And then we have short-term rental property number of bedrooms. And this is significant in terms of determining the maximum occupancy when we have a short-term rental that we're considering. So number of bedrooms is determined by the official records of the Oldham County Property Valuation Administrator. And in working with this with the Study Review Committee, we felt like that was probably the most objective measure that we could come up with versus something subjective where someone may say, oh, I have a futon or I have a pull-out couch, so that should go towards my maximum occupancy, which is a very subjective decision. So we went with something objective, which is basically what does the Property Valuation Administrator show? And then we define our maximum occupancy that you would expect in a dwelling unit. Twice the number of bedrooms plus 4 determines the maximum allowable number of transient guests at a short-term rental property. Okay, the short-term rental property permit, which Ryan will be going over, is a required permit that is reviewed by our office authorizing the establishment and operation of a short-term rental property for a defined period of time. And these next few definitions go quick because really they just kind of set up what we're going to be talking about in terms of licensing and registering the short-term rental. Change of property ownership is just what it says, the transfer of property ownership title from one host to another host. Change of manager, the transfer manager from one individual to another individual. The hosting platform is a person and/or entity that provides a means through which a host may offer a short-term rental property for transient occupancy. Typically, these hosting platforms are internet-based where you access them through your desktop, your tablet, or the phone that you've got in your pocket or purse. Short-term rental property house rules. Basically, the house rules, as we go over them further, are just the establishment of the fact that anyone who's renting a piece of property should be a good neighbor to the people that are adjacent and in the neighborhood that that short-term rental is located at. And then we're done with the definitions. So the next section is where short-term rentals allowed. And what I've got here now is what's actually in the ordinance that's identical to what's in your all's text that you were provided. But for explanation purposes, I'm going to go to these next couple slides because what we found in working with the Study Review Committee and gathering input from neighbors and then also what we've heard through public hearings with our Board of Adjustments is that there's a big difference when a short-term rental is owner-occupied versus non-owner-occupied. That we're finding when it's owner-occupied in terms of the licensing, we're really not having much in the way of negative impact on the neighbors. When it's non-owner occupied, it's a different story. So what we've proposed in working with the Study Review Committee is that if someone is an owner-occupied host proposing a short-term rental, that they would need to go to the Board of Adjustments and get a conditional use. That way, neighbors are notified and aware of the fact that someone set up a short-term rental property next to them. Currently, that's not a requirement in the existing ordinance. And then what we've done to address all the heartburn and disagreement that's come about with non-owner occupied short-term rentals, we've basically said if it's in a residentially zoned property and it's a commercial activity being ran by someone who's not living there, it may not be a good idea. So the proposal would be that owner occupied would, in a residential zoning district, would go to the Board of Adjustments, go through a public hearing and notice process to get approval. Non-owner occupied would not be allowed in a residential zoning district. And the things that have not changed in terms of where they're allowed, basically, if it's owner occupied or non-owner occupied, and it's in a non-residential zoning district, which means it's office or commercial or industrial, it's probably reasonable to expect as a neighbor that you would have commercial activity potentially next door to you. So with that, I'm going to, I can take questions, but my suspicion is I may say, well, I think Ryan's getting ready to talk about that. I'm going to hand the baton to Ryan here and sit down and let you guys hear his voice for a bit.
All right, thank you. Ryan Fisher, Senior Planner with Oldham County Planning and Development. As Brian stated, I'll be handling the next 3 sections, starting with our operating requirements and standards. We'll be talking about the permitting process and looking into what the application entails. And then lastly, we'll touch on what happens when that permit expires, what happens when we need to renew that permit, and what happens if planning and zoning and code enforcement need to look at revocation of a permit. So with that being said, we'll start in. So the first one here we'll look at is a host shall not establish, operate, and/or advertise a short-term rental property without first having obtained that short-term rental property permit. That is exactly the same as what's in our current ordinance, but we have placed in there verbiage to say they also have to be maintained in good standing. That'll be important once we get to the renewal and the revocation of that permit. So they must maintain good standing as well with their short-term property permit. The next one, a short-term rental property, Brian mentioned this in the definitions, but short-term rental property shall only be available for transient occupancy for a time period less than 30 consecutive days. So our short-term rental property permit only deals with anything less than 30 days of rental. Third one, a short-term rental property shall be limited to a single contractual transient guest at a time. Simultaneous rental contracts are prohibited. And additionally, the short-term rental property cannot be advertised on a hosting platform as concurrently available while under contract with a transient guest. Number 4, the contractual transient guest of a short-term rental property shall be a minimum of 21 years of age. That is exactly what it is currently in our current ordinance. The 5th one, the host shall obtain, continuously maintain, and pay premiums for insurance policies that cover that short-term rental property as a commercial activity. Number 6, the host or hosting platform shall be required to collect and remit all applicable room occupancy and sales taxes as required by federal, state, and local government. Number 7 is the host shall be responsible for compliance with any current applicable laws and regulations of the federal, state, or local governments, as may be amended from time to time, but not included to any laws or regulations on non-discrimination, zoning, building, safety, property maintenance, health and sanitation, fire, electrical, plumbing, mechanical, and all other applicable laws. The host shall use reasonable property management practices to ensure that transient guests and visitors of that short-term rental property don't create noise disturbances, engage in disorderly conduct, and or violate provisions of federal, state, and local regulations. And once again, just trying to ensure that the transient guests are good neighbors to those who do live within the county. Number 9, the host shall post and maintain a copy of the current short-term rental property permit on the hosting platform. So on the Airbnb site, anything like that, they've got to have a copy of that permit, and on the inside of the short-term rental property unit in a conspicuous location near the primary door. That's very similar verbiage into what's currently in our ordinance now, that does have to be posted on the actual website as well as in the dwelling itself. Number 10, the host shall post and maintain inside the short-term rental property unit in a conspicuous location the following minimum house rules adopted by local ordinance for the use of transient guests. So Brian alluded to these house rules in his definition, and so just looking at each of these individually, the name of the manager, including all of their contact information, as well as the name of the host and their contact information. And that contact information includes their postal mailing address, email address, telephone number, where they can be reached, 24 hours a day, okay, 7 days a week. And then the maximum number of transient guests authorized to exercise that transient occupancy. So once again, 2 times the number of bedrooms plus an additional 4 gives us that maximum occupancy, which is listed on the short-term rental property permit. So that number has to be on there as well. Evacuation routes in case of an emergency on how to get out of the dwelling. Parking locations, which shall be on the same property in which the short-term rental property unit is located, not on adjoining properties or streets, anything like that. Most of our neighborhoods, we don't allow that street parking anyways, but in addition to being a good neighbor and making sure all those transient guests are parking on their property and not other people's. The trash pickup day and that trash and refuse shall not be stored within public view, except in proper containers with a closable lid. Any device or machine utilized for the amplification of sound shall not be audible at the adjoining property line. So once again, being a good neighbor, not to make sure that the noise traveling across to other properties. And then the last one, outdoor and group activities shall not occur during the hours of 10 p.m. to 7 a.m. So those are those lists of house rules. Number 11, outdoor signage. Currently, that's not allowed with our short-term rental property permit. This is the same thing here, outdoor signage, which identifies the short-term rental property in residentially zoned areas is prohibited. And then outdoor signage, which identifies that short-term rental in our non-residentially zoned areas, so those commercial areas, things of that nature, must obtain a sign permit. So, parking shall be provided on the same property. I touched on this a second ago. The minimum number of parking spaces that will be allowed will be based on that maximum occupancy. So that shall be determined by that number divided by 2.5. All right. Trash and refuse shall not be stored within public views except in proper containers with a closable lid. We talk about the noise again, with any device or machine utilized for that amplification of sound shall not be audible at the property line of the short-term rental property. And then those outdoor and group activities shall not occur between the hours of 10 p.m. and 7 a.m. And then we provide some examples of those activities, including but not limited to swimming, hot tubbing, grilling, yard games, campfires, etc. As far as the permit goes and applying for the permit, once again, no person, firm, or corporation shall operate a short-term rental property or put that on a hosting platform without having a short-term rental property permit and that being registered annually with our department. Those applications shall include the payment of the application fee. Currently, that is $150 for an initial application and then a $100 yearly renewal. The completed application form, and then accompanying supporting information consisting of the following. Once again, the host and the manager, all the information on where they can be reached 24 hours a day, 7 days a week. A floor plan of the unit, that's going to show their number of bedrooms, details of all levels of that dwelling unit, including those locations of windows for egress purposes, any attached structures, doors, interior and exterior in the building, and then locations of those required smoke detectors. Shall require a plot plan of the property showing the shape of the property, the location of the dwelling unit, location of all other structures, as well as the driveway and those required parking spaces, which we touched on. The owner-occupied host, so in those areas that an owner-occupied short-term rental is allowed, they must provide proof of their primary residence and provide 2 documents verifying that. And then we have listed there all of the acceptable documents that are allowed to go ahead and verify the residency of that owner-occupied permit. Proof of your insurance policies that cover that short-term rental as a commercial activity. And then a written statement from the applicant that has confirmed that operating the proposed short-term rental property does not violate any homeowners association agreements or bylaws, condo agreements, covenants, codes, restrictions, or any other agreement that governs or limits the use of that proposed short-term rental. And then lastly, we look here at the expiration and the renewal or the revocation of those permits. All of our short-term rental property permits expire December 31st of every calendar year. That's the way it is right now. So the same thing here shall be continuously maintained by the host and will expire on December 31st every year. And then, if any of these events occur prior to December 31st, that shall trigger an expiration of the permit as well. So when we look at these, if we have a change of property ownership, if we have a change of manager, we have a change of the insurance policy, change in the maximum number of bedrooms, if we do any sort of home improvement work and add another bedroom, or a change in the status of any previously approved conditional use that may have been issued at that Board of Adjustments hearing, all of those would necessitate that applicant has to come in and renew their permit prior to December 31st. And then lastly, a renewal application grace period of 30 days will be allowed from the date of that triggering event. So any of those 5 things that I just listed to look at that renewal of that permit. Short-term rental property permits shall be subject to revocation by Planning and Development Services in the event of any of the following occurrences. So if we look at having to revoke a permit for any reason, first one is failure of that host to submit accurate and true information within that application. Failure of the host to renew an expired short-term rental property permit by the ordinary December 31st renewal date every year. Third one is failure of the host to renew an expired short-term rental property permit that has been triggered by one of those events that we just touched on in the previous slide, whether that be a change of ownership or change of insurance policy. Fourth one is advertising on a hosting platform and occupancy that exceeds the allowable maximum occupancy. So if our permit states that you are only allowed 10 occupants and somebody finds on one of these hosting platforms you're advertising it for 20 people, that can be something that triggers revocation. Enforcement action undertaken by planning and development regarding the operation of that short-term rental property, probably by code enforcement if we get calls for noise complaints and things of that nature. And then 2 or more validated civil and or criminal complaints regarding the operation of that short-term rental property and or conduct of any of the transient guests that are on that property. In the event of that revocation, an administrative appeal may be done by the applicant or by the host using the appropriate Board of Adjustments and appeals process that we have now. And then in the event of a revocation of that permit, the host can't make another application for a different short-term rental on that same property for a period of at least 1 year. And I think with that being said, Jim is going to come up.
Great job. I appreciate the work that Ryan and Brian have done on this, and especially explaining to you all what we're doing here. What you're seeing, as Brian mentioned in the very beginning, is the actual revised version of it. We didn't do a strike through and red line because it's just so complicated when you get into these changes. But we are asking you to repeal and replace section 250.050 with a short-term rental property of Oldham County Comprehensive Zoning Ordinance, and that your decision regarding KOC 23920391 will apply to areas of Oldham County with the exception of the cities of LaGrange. Actually, it does include Crestwood, but not Pee Wee Valley. Let me say this. First of all, I want to clarify one thing. There are two, we use the word permit in 2 places, and I want to make sure, and we're going to actually stop calling the second one a permit and call it the license. Conditional use permit. That's when you go to the Board of Adjustments, public meeting, and you're granted a conditional use. In this case, it would be for a short-term rental. The second step is what we're calling permit. We're going to change to license, as Brian kind of mentioned. That's when you actually make the application. After you get the conditional use permit, you will then come in and get your license. So I just wanted to clarify that real quickly before I made some conclusionary statements. First of all, I want to say, and you probably have seen this, we are not the only jurisdiction making these changes to the short-term rental regulations. The city of Louisville has. The city of New York City has. Everybody is addressing this as a growing industry, and nobody is really trying to stop it as a means for allowing people to stay on property that would normally be residential in nature, and especially here, even in Oldham County. What significantly changed was that the Supreme Court ruling of Hensley versus Gadd clearly defined short-term rentals as a commercial activity. I want to say that commercial activities are not permitted by right in residential neighborhoods. You can do a conditional use permit, which is what we're recommending. The significant difference here, and mostly because in our recent conditional use applications in front of the Board of Adjustments, especially for the non-owner occupied, is that there have been an increase in investment companies investing in houses and having off-site managers manage the properties. And then we've seen an increase in residents coming to these meetings with significant concerns. And so our Board of Adjustments has been challenged with making a decision on whether or not this is a desirable thing for the community, and they do it on a case-by-case basis. And I believe the Board of Adjustments is an excellent body making excellent decisions. So, as mentioned up here, Pewee Valley has actually taken short-term rentals out of their ordinance completely, except in commercial properties, and there are 2 in Pewee Valley. There are not any people being able to apply for short-term rentals in the city of Pewee Valley. The reason that LaGrange is not included in this is that they issue their own short-term rentals. So again, these changes aren't something that we just dreamed up and not intended to block them completely. They're intended to allow owner-occupied people the opportunity to potentially rent their houses, but significantly make sure that there is transparency and they go in front of the Board of Adjustments for conditional use. So with that, Judge, if you want to ask either staff questions or take public comment, that would be your pleasure.
Well, we'll take the public comment. As I mentioned at the beginning of the meeting or beginning of this session, this is a public hearing. Anyone who's here today who would like to speak in favor of these changes or in opposition to these changes will be allowed to do so. Each person who is to speak is going to be sworn in. You're expected to come forward, state your name and your address. Anyone who refuses to be sworn in or refuses to give us their address, their testimony will be struck. So I'll ask now if there is anyone who would like to speak in favor or in opposition of these proposed changes. Please stand now. And I ask you to raise your right hand. And do you solemnly swear to tell the truth, the entire truth, and nothing but the truth, so help you God? All right, you are sworn in. Please do not come forward if you haven't been sworn in. Now I'm going to ask those who would like to speak first in favor of these changes. Is there anybody here who would like to speak in favor of the changes? Please come forward. Pardon? Yeah, we will allow 50 minutes overall for speaking in favor or in opposition. Each speaker will allow 4 minutes. All right, please state your name and address.
Bill Hillebrand, 1104 Riverside Drive, Prospect, Kentucky. Okay. I'll try to make this very quick. We along the river are very affected by this. Many of the subdivisions along the river are affected by this because, it's a nice place. We have seen the results even recently. If I could give two recent examples, we had one short-term rental last week in a 15-mile-an-hour speed limit zone. Crushed the entire front of his truck into a guardrail in a 15-mile-an-hour speed limit. Not the kind of person you want in your neighborhood or ours. We also had one, I believe it was toward the beginning of the year, a new short-term rental owner that came in and violated building and zoning codes by not taking out permits to do work on their house. They received stop work permits, planning and zoning did everything they were supposed to do. But again, that is not the kind of person we want in Oldham County or as our neighbors, trying to circumvent laws and rules that are in place. I strongly urge you guys and ladies to vote for this amendment. Preserve the integrity and character of all of our neighborhoods, including your own, and do this for your neighbors and for your fellow Oldham Countyans, not for the commercial interests that are coming into our neighborhoods and into our county. Thank you.
All right, thank you. Anyone else who'd like to speak in favor of the ordinance? Please stand, come forward.
My name is William Schmidt. I reside at 1110 Riverside Drive in Prospect. I am both a resident of the community of Harmony Village, which is a 65-home residential community with riverfront, and therefore is an attractive.
Can you project a little bit more, Mr. Schmidt?
It is an attractive location for this kind of activity. The essential elements have been covered and discussed of what the new ordinance would require. I want to take a moment to commend the two gentlemen here who've done most work on this, which is Ryan Fisher, Brian Foley, on working with the study committee and with the community and those of us that participated with them in addressing all of our concerns. They've done an excellent job, and the change that have made pretty much resolve our concerns. Most specifically in the case of our location, which is a community on a one-lane street, okay, with riverfront, okay, so it has to do with parking, excess parking. Many of the changes that have been made have been to address things that we have observed occur because we have had in the last 2 years the Board of Adjustments approve for both conditional use permits and short-term rental permits in our community. And so we've been able to observe what that does in terms of what it brings in to traffic, to noise, and to safety issues, just as Mr. Hildebrand discussed of just the last couple of weeks or so. So I want to say thank you very much for your work, and I want to urge you, please, to adopt this, because the particular feature of this, which implements Hensley versus Gadd, the Supreme Court finding of no commercial property, by this change in this zoning ordinance precluding non-owner occupied short-term rentals in residential areas in Oldham County, you will be making a tremendous improvement in guaranteeing the safety and sanctity of residential communities in Oldham County. And we thank you for your consideration in doing that.
All right, Mr. Schmidt, thank you.
Thank you.
I'm Jim Allen, 1416 Oldham View Drive. Most of what I was going to say has already been said. I speak in favor of the ordinance. I've lived through this STR thing now for about 1.5 years, so I think some of you are aware of that. And so I kind of went to the study group meetings to try and help share my experience, both the good, the bad, and the ugly. And I have to say that, bear saying again, that the committee did a great job in trying to listen to what we were saying, take a look at the very broad scope of this, not just the ordinance, but if you don't do the ordinance, what does it mean? You know, how do leases play into this? How does the community, homeowners associations and those communities that are not organized, you know, deal with situations where the county gives them permits to do things and then we have to undo it? It's very difficult. So this is a very balanced approach. It doesn't prevent people from having short-term rentals. It helps those of us that are kind of unorganized become aware of it and help respond to it. So I have no financial interest in this anymore, and I hope that as you listen to some of these other discussions, you consider the desire of the residents to kind of live without a business in their neighborhoods is probably more important than the business aspect of it. So thank you very much, and thank you, gents, again.
I'm Karen Morose Hunstiger. I live at 1616 Crestview Drive in LaGrange. I want to thank the community for bringing this to the body and for listening to all of us at the meetings and then taking that information and coming up with something that's easy to understand. So I hope you all vote for this because it will keep us all safe. Thank you.
Is there anyone else who would like to speak in favor of the proposed changes? Seeing no one, now I'll allow those who would like to speak in opposition to the changes to come forward.
Good afternoon, Austin Hayes, 1124 Riverside Drive. My wife and I own the house there. It's been a positive experience for us to have a short-term rental there. Our family has used it. We used it last weekend. We were there, my wife's there about every other day, cleaning it, keeping the yard in shape. It's been a positive experience. We've had long-term rentals before. Many of those times you get stuck with the renter. You have to go through the whole eviction process. We feel like it's a beneficial thing to Oldham County to have the short-term rentals. It prevents more hotels, allows tourism dollars. We pay the taxes. We went through the process with Jim and the folks to get permits. We're cleaning this property more than we even clean our own personal house, frankly. Because we have a vested interest to keep this property in a really, really good shape. If it's in bad shape, we don't rent it. All the reviews are online. If we get bad reviews, it kills our rental property. We're not an investment company. My wife and I own it individually. We have kids in school here. That's why she's not here today. She's picking up kids right now at Goshen. We have a son at North Oldham, my stepson. And so we're not coming in from New York City or Louisville or whatever it might be. We're here in the community, and a big concern I have with these changes, and I would request some sort of clarification, is that if there's a change in an insurance policy, does that revoke our license? Okay. So when you all said change in insurance, what does that require?
Yeah, Judge, is it okay if I answer that? Because that may be a concern based upon some of the phone calls we've gotten in the past couple days. So with that licensing requirement, if nothing changes from January 1st to December 31st, your license just keeps going on, but then you're required to renew it by December 31st. But if something happens, one of those 5 triggers, sometime between that time, it's your responsibility to come in and just file a revised application to say, hey, my insurance carrier changed. It doesn't revoke your license. It just puts us on notice of the fact that your insurance carrier changed, so we've got that on file.
Okay. And then one other thing, on the non-owner occupied, because that's our particular situation, will those be grandfathered in?
You got a conditional use of the board, right? Yes. Yes, and Attorney Baxter can comment on this if you like, or I can answer it.
So this is an issue that came up in front of the Board of Adjustments actually last month, because there was at least one and maybe 2 of these, I don't remember, on, but questions were raised. And the standard, as I see it, is that everything that is in effect right now and is legal right now remains legal right now. There's no revocation of any of your right to operate the short-term rental. So this is going to apply to short-term rentals as they go forward. So if you have the right to operate a short-term rental today, that right will continue and, unless you do something that results in it being revoked.
Does that run with the land? Like if I sell it to another owner, do they have to go through the whole process?
I think you've got a permit that's filed of record, as I recall, yes.
So if we sold it to another third party, that third party could get the same license to operate a non-owner occupied?
Has to do with the property, yes.
Okay.
It's not personal to you, it is tied to the property.
Tied to the property, okay. Thank you.
All right, thank you.
Afternoon,
Hello.
Judge and Magistrates. My name is Jason Keister. My address is 10420 Covered Bridge Road. We've lived there about 3 years now. Actually, this month is 3 years. We love Oldham County. It's beautiful. We operate a short-term rental on our property, so my situation's a little bit different than the gentleman that just spoke. But my wife and I, about 3 months ago, started looking for other properties that we could buy within Oldham County to also rent as on Airbnb, which is the platform we use for ours at our house. We have a separate building on our property that people stay in. When I heard about this reading on Friday, I wanted to come and speak because that's kind of stopped us from looking over the weekend. We decided, hey, we better not buy anything until we find out what's happening with the laws here. But I wanted to come and speak and let you guys know that we've rented on that platform for about 5 years. We moved here from Oregon, and we did 2 years in Oregon and 3 years here. I've rented to over 500 different people, and I've only had problems with people twice. And they've been minor issues with noise in the evening that we were able to abate and complete. The place that we have here is on our property. The one in Oregon was off of our property. So we try to limit the number of, we limit the number of people that we rent to that have no reviews or very few reviews. So if people have bad reviews on our platform or are not good tenants in the past at other places, then we won't rent to them at our location because we don't want to bring that kind of problem in. So I'm wondering if there's some way that we can make another adjustment to the proposal where people that live in Oldham County that are good tenants and have the ability to maintain the property and they're close by, if they could still have a non-owner occupied permit. Am I saying the right permit instead of license? Versus just saying no one can have one at all. Because we would like to buy another couple of properties here and stay here. We love Oldham County, we like where we live, and we'd like to move forward and purchase some things. But I'm a little hesitant to now based on what I'm finding out with this.
And, all right, you can, that question, does anybody want to answer that? He's asking if he can have a non-owner occupied. I'd like to follow up. Mr. Baxter just said that the status of the property goes with the property. So if we let you have a non-owner occupied property, what happens later when you sell it to somebody else who doesn't live in Oldham County? So I would say that the answer to that question at the present time would be no.
No. Okay.
We would be creating a problem for ourselves.
Okay.
Let me just really quickly explain it this way. Again, the Supreme Court has ruled that these are commercial activities. People move into residences expecting residential in nature. Now, granted, there are rentals that are long-term, and that's not what this has to do with. It's the transient nature of short-term rentals that make it commercial. So this ordinance, and my answer being I agree with the judge that it wouldn't apply, is these are commercial investments. They are not residential investments. So that would be my response.
Okay. Well, thank you. I appreciate it.
All right, I understand your business point of view there.
Yeah.
But you see what the purpose, I believe, of what is being proposed here is to maintain a tight grip. Now, if the property, let's say, designation was left to the owner and not connected to the property, might have a different point of view on the thing.
Mm-hmm.
But you pick up 10 properties around town, around the county that are non-owner occupied, and then you sell them to somebody from Michigan, that's defeating, I think, what the Planning Commission is trying to propose here.
Well, and you can do it a zone piece of property, you can buy it and rent it.
Yes, yeah.
Okay.
Okay, thank you.
All right, thank you.
Steve Redmeyer, 4019 Sheehan Drive in Buckner. I have a concern about the language requiring the personally identifiable information first off on the platform, whether it be VRBO or Airbnb or whatever, but also posted in the property, and that's a safety risk. That's a safety risk to post your personally identifiable information out there for whoever to see. No, it requires both the property manager and the owner.
You're renting your property out for a business purpose, and in order for, even if there was somebody that rented, if they had a problem, it needs to be posted somewhere where they can make contact.
Right, and therefore posted inside the property is
Right.
appropriate, but having to have that same thing posted on the platform is the issue.
That's not what we're saying in the regs.
Well, it's specifically written that way in the.
Page 4, but I didn't
I'll look
see
real
it
quick,
on-
Judge. I think what we're saying in terms of what has to be posted on, like the Airbnb platform is, I know I'm trying to get rid of it. I can't find my mouse. Yeah, I know. I'm trying to get the mouse here to respond. I think what the ordinance says, my recollection is that posted on the Airbnb or whatever the hosting platform
read it.
is,
Read it.
that you have to post the fact that you have a permit, but not all the details of the permit. You know, that you have to show that you're in compliance with the local ordinance. There we go. If you see it before I do, yell.
It's,
Did I? 9 and 10, thank you.
10.
Got it.
Yeah,
Okay.
The permit has all that information.
No, the permit will not
It
have.
does currently.
Okay, currently it may have the owner's mailing address. And this gets to the part of, you know, when you guys pass an ordinance, and I'll talk about this one specifically, but it applies to every ordinance you all pass. You have to rely on staff to then implement it, because we've already talked within the office that if fiscal court passes this, we have to come up with a new permit application. You know, and with that permit application, we can address privacy concerns like this to where when we issue the actual permit, it'll have the person's name, but it doesn't have to have their address or their contact information in terms of what would get posted on the internet. And again, it gets to the fact that this is a commercial operation. So there are some things that you should expect with that.
My next concern is the 10 p.m. to whatever it was. So I have a fire pit in my backyard, and based on what you're saying, a couple cannot rent my home and sit out at that fire pit and just have a romantic evening. And
we've had this conversation with the study review committee, and it's a great question because it's a real world question here. The reality is that we don't have a code enforcement officer between 10 p.m. and 7 a.m. or on the weekends. And if a couple's having a romantic moment around a fire on their property, that's probably not going to cause the neighbors to call the police to come out and file a report, which would trigger code enforcement from us. It's one of those things, we need that standard in there, but there's a dose of common sense that goes in there too. That if someone's going with the scenario that he just explained, it's not creating a problem. But if you've got the case where you've got a group of people who've showed up at a house and they've got a bonfire going and hooting and hollering and other stuff, and it creates a problem, now we've got something in the ordinance that we can use to address that.
could we have language that maybe was a little more if they're breaking existing ordinances, then that's a problem. But if it would be all right if I and my wife were in my backyard doing whatever is being done, then the transient ought also be able to do that. I mean, it just seems.
Well, I think the way Brian just explained it is realistic. You know, it's really for the bad actors, not for the good ones. Nobody is going to go out and say, oh, it's 10:15, you're in your backyard, you need to go in the house. It's when it becomes problematic. Magistrate Dye just asked me a question today about a person who lives in a house who put in a pickleball court, and they're creating noise for neighbors, not at 6 p.m., but at 10 o'clock and 11 o'clock because they put out lights. So a lot of times regulations are written, unfortunately, for the bad actors. It doesn't affect the good ones.
That's all I've got. Thank you.
All right, thank you.
If you ain't got one up at 10 o'clock, you might go on bed.
Thank you. Good afternoon. My name is Ken McFarland, 7216 Oregon Creek Road. My wife is Dr. Rebecca McFarland. We moved to Kentucky in 2004 to raise our family. We have 6 children. Rebecca provides medical care to many Oldham County residents at LaGrange Baptist Hospital. We go to church in Oldham County. We are invested personally and financially here. We own 5 homes in Oldham County. I manage several long-term rentals and short-term rentals. These short-term rentals are non-owner occupied, specifically what I'm addressing. I also own them in Jefferson County and Indiana. With our short-term rentals, specifically, we seek to offer comfortable, quiet, peaceful housing environment for visitors coming to see family, business travelers, tourists, and families relocating to this area. We have operated short-term accommodations at several different locations since 2017 and have had very good experience with our guests. Some of the people and situations we've been able to help are the following. An international robotics team competing in DARPA Robotics Challenge, they won $500,000. I think they spent some of that money in Oldham County. Mother and daughter refugee from Ukraine until they could secure permanent housing. A polo player, he wanted to stay in Oldham County, not Louisville. International aid worker during the pandemic. Missionaries on home from leave from Africa. International business owners. Family displaced due to home fire. Traveling medical personnel. Of course, Kentucky Derby attendees. Several families relocating that needed a few days or weeks, and in some cases months of extra time before moving into their new homes in Oldham County. During the pandemic, elderly and immune-compromised individuals that needed a getaway were able to stay in our safe, clean environment, no other guests around. This is not possible in a hotel or an owner-occupied short-term rental. With the elimination of owner-occupied short-term rentals, opportunities to serve the greater community with flexible housing cannot be possible. One of my properties alone has welcomed over 1,000 visitors to Oldham County. 1,000. Many others here have been welcomed with hospitality that Oldham County provides with short-term housing options through local Kentucky property owners such as us. Having safe, well-managed local Kentucky short-term options for visitors to Oldham County is vital to the success and responsible growth that our county needs. With the elimination of the short-term rentals and these proposals, the opportunities to serve others with this flexible type of housing is not possible. Traditional long-term rentals do not provide this flexibility and do not allow for the situations and opportunities that I've mentioned. Options for short-term stays especially are limited, and our community does benefit financially, significantly, and socially when we operate short-term housing responsibly. Visiting relatives, business travelers, and tourists benefit our area, and we need to be hospitable and kind to show them what Kentucky has to offer. Are we not the kindness capital of Kentucky? I ask each of you to vote down the passing of this ordinance, of the revision of this ordinance 250050. This ordinance, as it is written, specifically targets me and others here. This county should not approve this ordinance. It is the responsibility of homeowners associations and neighborhoods to address, if they so choose, these various restrictions that have been stated in this document. I'd like to offer my expertise and experience of crafting a better and more responsible short-term rental ordinance plan for Oldham County. Owning and managing several of these for years, I was never informed of any of these meetings, going back to April. One simple suggestion is to encourage local Kentucky ownership because these entrepreneurs and business owners have a vested interest in this community, not just making money. This will avoid the issue of people that encounter with, say, a large company, a state corporation, out-of-state corporation buying a bunch of houses and then...
Judge,
I understand.
can we give him more time?
No. Your 4 minutes, Mr. McFarland. How much more do you have?
I
there?
also provide I would provide my personal number to any neighbors that they would call. I want my guests to be good neighbors in Oldham County. The board should not approve this ordinance. I ask each of you to vote down the passing of this revision of ordinance 250050.
Right.
Thank you.
Thank you.
Do you have any questions for me?
Now, right now. The next speaker is welcome.
Hello, Justin Bouchard, 13403 Longwood Lane, Goshen. My wife and I have operated a relaxing river retreat since April of 21. That's 2.5 years. We're non-owner occupied with conditional use and STR permit. We reside 10 minutes away at our home in Oldham County. It's a single-family home on the Ohio River at Tartan's Landing Marina and has a pool. And we host primarily through the Airbnb platform. We're superhost status, and we've had a 5-star review from over 47 guests, and 99% of those guests have not given us an ounce of problem. Some of the value we provide to Oldham County: a beautiful, tranquil setting for visitors to experience Oldham County in line with the county's development plan and desired image. Access to affordable housing lodging close to Oldham County attractions that would otherwise be unavailable and drive guests of Oldham County to Jefferson County. And obviously tax revenue from accommodating guests in Oldham County and striving to do things right and per the rules and requirements. We've had some unexpected opportunities from this short-term rental. We provided housing to a family of LaGrange. You might know, a place to live while their home was being renovated by HGTV, was televised nationally. That was 5.5 weeks. Provided an opportunity for a family that was moving back to Oldham County from Florida, a place to live temporarily while they searched for their home. They stayed with us for 4 months. A gentleman from Colorado bought a boat here. He's been renovating it to do the Great Loop and calling Louisville his base of operations. Multiple local families have used our place, including our next door neighbors when they had family in town and couldn't accommodate everybody themselves. So all those opportunities existed because we have a non-owner occupied short-term rental. If we were driven to a long-term rental business model, we wouldn't be able to provide that opportunity to those folks. I'd like to address just a few things that have come up. One is the concept of Hensley versus Gadd. I'm not a lawyer, not an expert in this at all, but one of the things that I've done in my reading on this is that the Kentucky Supreme Court, they found reasoning to find short-term rentals barred by the deed of restrictions for that subdivision, not the zoning regulations that those were under. So it is a little bit of a different case in just the fact that they stated in the findings and the opinions that it was a commercial operation. It's not an apples to apples comparison to where we're trying to go with this regulation. I echo the comments about providing a copy of the permit on the website that contains personal identifiable information. The current regulation requires us to put the STR number on there. We do that. That is sufficient. We shouldn't have to put the actual copy of it that has our name, address, phone number, email address, all that kind of stuff. The problems that are mentioned by the proponents earlier in this session, they're all addressable by the current regulations that are in place and enforcement that are in place. We haven't had any of those that we're aware of at our location, and of course we would work with the tenants and any enforcement personnel to address those issues. I'm happy to hear about the grandfathering clause. That makes a big difference to us. I'd like to see that language actually in the ordinance itself, because we've heard it said twice that it will go with the land. You'll be grandfathered. I'd like to see the proof in the regulation and in the language. The requirement to address commercial insurance. So question is every commercial operation in the county of Oldham County required to provide proof of commercial insurance.
Pardon me?
Okay, okay, fair enough. So there, it's an open-ended question. It needs to be addressed. Having one segment of the population, one business owner.
Judge is out of time.
Pardon?
It's out of time. Can we give him some more time?
Are you just about finished?
If
or-
I can finish just this thought, since he was
sure.
not able to address the question. So provide, if one segment of the business community has to provide insurance to be permitted to do their business, is that required of all others? My guess is no, but I would ask for that to be fair and equally applied across the board.
Okay.
So
Thank you.
Thank you very much.
All right. Anyone else like to address this subject?
Wes Johnson, I live at 3341 North Buckeye Lane on the river. Seems like apparently the river's driving a lot of this. Quickly, I moved to Kentucky 20 years ago from Atlanta, big city. Lived in Louisville for 10 years. I hated this place. Would do anything to get back to the South. And then I found Oldham County about 10 years ago. I moved out here with my wife. We have 2 kids in Oldham County schools. I fell in love with this place, the farms, the destinations, just Oldham County as a whole, the community out here. Surprised to see how many people today never venture out to Oldham County. We eat downtown almost every night. We meet families who travel, and almost daily we're pushing people out to restaurants and community activities out in Oldham County. The sad thing about Oldham County is it's a drive, and people in Louisville are not used to making the drive. I'm from Atlanta. We spend 3 hours a day in the car. We need places out here for people to stay. There are several business owners, farm owners who have invested significant amount of money over the last couple years in facilities out here to host weddings and parties, and they've done a phenomenal job. Matter of fact, world-class facilities. Ashburn Farms and Barn 8, Hermitage Farms have invested significant amount of money into these facilities. The problem is those facilities don't have the ability to house people. So people are driving out and then having to turn around and drive all the way back downtown and stay downtown because there's no places for them to stay out here. Short-term rentals, and not just VRBOs. We operate a property that we're required to have a conditional use permit, and we do adjoin property. We're separated by Buckeye Lane. Our house is on one side of the street with 2 lots. We have 4 lots across the street with a property that's on the river. I call that adjoining just because we're split between Buckeye. We own 7 lots together, but we're forced to get a conditional use permit, I guess, because of Buckeye Lane. No big deal. We did that. Our problem is the verbiage that's in here today. We would like to see the grandfather clause in there at minimum. But what we would really ask is that not only that it's not approved, I think much of what is in here is good language. I think much of what is in here protects our neighborhoods, our communities, our neighbors, and addresses a lot of the concerns of the people that are here in opposition of short-term rental. The problem is the way it's written today is too confining. It doesn't address those issues. And what, I guess it wasn't Jim, but one of the things they had mentioned earlier about the difference between subjective and objective is that this leaves an objective view. Well, to stand up here and say that we've written an ordinance, that it's all a matter of interpretation, you can sit out by the fire at 10 o'clock if you want, as long as you're not causing a problem. The problem is if my neighbor is opposed to me doing that, and he takes a picture of me, then we are, in fact, going against what the ordinance says. And our conditional use permit could be revoked because of that. All it takes is a neighbor doing that 2 times the way the ordinance is written, and that could be pulled. That's objective. That's the way it's been written. So if our intent is to enforce these ordinances, let's change the verbiage. And all I'm asking is that we can hit pause on it. I understand they did a significant amount of work to get to this point. I respect that. I respect all y'all's time that's gone in it and the neighbors who have been here in opposition. But it seems like in talking to a bunch of the neighbors who have conditional use permits, we weren't notified, and maybe we didn't see the notice. I didn't see it. Otherwise, we would have been here and helped be part of the solution to craft something that works for everybody. That's what we want as well. We did talk to Kim, the head of Oldham County Tourism. She's in favor of this. She's in favor of getting people out here. She wants it. I'd encourage you guys to talk to her and talk to her about the impact this will make on all the business owners who spent millions upon millions of dollars to bring business out here, that we are now putting a really big strain on them by pulling this ability to do that. So thank you, guys.
Okay,
I wish
thank you.
would
All right.
consider, at minimum, hitting pause
Okay.
and pulling a committee back together.
All right. Let's try to stay within our 4-minute time limit, please. Someone else?
Good afternoon. I'm Kristen Bouchard, 13403 Longwood Lane.
Could you speak a little louder, please?
Yes,
I can't
sorry.
hear you, so I don't think anybody behind you can hear you.
No problem.
Could you give your name again, please?
Kristen Bouchard, 13403 Longwood Lane. So again, just to echo some of the comments about how those of us who are currently operating non-owner occupied short-term rentals were not aware of the committee or the meetings that had gone on thus far. I think there have been inadequate notification of this particular second reading. I did not find it in the September 28th Oldham era as a notice that the second reading was going to occur, if that is a responsibility. Also, I called as of 8:20 a.m. yesterday morning. The agenda did not include this topic on today's schedule. When I notified the person that answered the phone, she said, "Oh, I do have the wrong agenda," and she corrected it before we hung up the phone. But my only hearing through the grapevine and then calling to find out for sure gave me very little time to prepare for the statements that we're making today. I think we've seen that this language is not mature enough at this point, though I too am in favor of a lot of these requirements, that it is a benefit to the community. I think we're not quite there and would recommend that we not vote on this today and take a little more time to clarify some of these things. Question about every time there is a change, do I pay the permit fee again? And then just the permit versus license language should be included as well. Those are some additional concerns. And then just again on the Hensley versus Gadd, seems to be a little bit of an overstretch in what that court case actually was determining, as that was very specific to the deed restrictions for Woodlawn Estates subdivision for that particular case. Thank you for your time, and definitely appreciate what these folks do for us. And those of us who are trying to follow the rules, we still want to be able to do that with clear language. So thank you.
Thank you. Anyone else?
Kim Hides, Executive Director of Oldham County Tourism, 6826 West Highway 22, Crestwood. I obviously have to speak on behalf of tourism because I am the one who sent out the notice that I got at 10 till 4 on Friday about the second reading. The first reading, I was out of town, so I couldn't attend the first reading. I did attend all of the study review committees and gave feedback. Was the only one in the room really that was trying to figure out a way to make it work and us not to eliminate short-term rentals at all. There was conversation about doing moratoriums and stopping short-term rentals countywide. And we really can't have that conversation to stop them countywide. 21, you may not know, 21.2% of tourism's budget that we use to market the county, the entire county, for business, for residents, for attractions, for restaurants, that comes from short-term rentals specifically. 21.2%, a fifth of our budget comes from short-term rentals. And I would hate to see that something passes without feedback from the people who do it right. We have almost 40 properties in this county that are permitted that do it the right way. We have very few people who complain for over almost 40 people in the county. I mean, to have the very few complaints that we have, we deal with those complaints. But this needs work. It needs people like this who do it right. It needs their input. It needs their feedback. Most of these people that have spoken today own more than one of these. They're more experts at it than we are. They run a good program. If you look at their ratings, they have good ratings on Airbnb. That's tough to do. Most of our properties in Oldham County are superhosts. That means they go above and beyond. That means their properties are spotless. That means they attend to issues that come up in a timely fashion. Oldham County does it right. And I think that we should focus on being the community that other communities come to for assistance in developing rights for short-term rental owners the right way. We shouldn't be the ones that are first in line to say we're not going to permit them. We feel like HOAs as tourism should be the ones who make the decisions for their subdivisions. And we have some that have already done so, and we are fine. That's not a complaint. You can do that. But to do a county-wide ordinance that affects the entire county instead of the problem areas. There have been numerous people talk about Riverside Drive and complaints on Riverside Drive. Well, one road, Riverside Drive, or a road and a half, has 5 short-term rentals on it. 5. So maybe one of the things that we should consider is how we limit those to Riverside Drive, how we limit them in Harmony Landing, or how we limit them in Crystal Lake, who also has passed something with their HOA that doesn't allow them. There's room for conversation before we start banning these or before we start saying that people can't operate in subdivisions, because a lot of people buy these subdivisions buy these houses and fix them up. They put money into these houses and they improve subdivisions. We are a good place to come, and we don't have enough hotel rooms. We don't have enough bed and breakfasts, as is apparent with 21.2% of our budget are specifically from short-term rentals. So we are excited to have that many short-term rentals. Like I said, we have almost 40 that contribute to the good experience that we offer in Oldham County. Thank you.
All right, thank you, Kim. Anyone else?
With only 40 permits in the entire county, it seems like a lot of effort has been put into.
What's your name, sir?
Say again?
We didn't get your name and address.
Oh, Daniel Guillory, I'm sorry. 1312 Riverside Drive, Prospect, Kentucky.
Daniel, did you say?
Guillory, G-U-I.
Are you sworn in?
Yes, sir.
Go ahead.
Okay. With only roughly 40 permits of the good players that have actually taken the time, gone through the process, seems like a lot of energy and effort on behalf of the county. Planning and zoning has really been taken against what could be used to improve other parts of the county. I have a long-term rental next to me on Riverside Drive that's been dilapidated for 4 years. Nothing's ever been done about it. I've made multiple complaints, still vinyl falling off of it. Long-term rentals can be just as bad or worse than short-term rentals. Keep in mind that just because the property is a rental property doesn't mean it's actually going to be a bad property. They're bad property owners, just the same as they're bad property short-term rental operators. A couple different things on the 250, 050. A lot of revisions still need to be made or just thrown out altogether. Everything that's addressed has been addressed appropriately. There's a process in place for the players who do want to participate in the process of getting a permit. If someone doesn't participate, then they should be banned. But everybody here, we've all done what we're supposed to do. And one thing that was said earlier that was incorrect was that Louisville has invalidated all residential and non-owner occupied properties. This is incorrect. I own multiple properties. I'm involved in almost a dozen properties in Jefferson County where they have not invalidated the new process of gaining permits for non-owner occupied property. Additionally, Hensley versus Gadd, that was for a neighborhood that specifically addressed short-term rental properties and commercial purposes. All of these properties, to the best of my knowledge that everybody has here, are all residential properties. Nobody's renting their duplex or threeplex or fourplex or renting their single family as a fourplex. Therefore, everything that is a single family is being rented as a single family residence, only to one person or one group at one point in time. The difference, you have these institutional investors that somebody was talking about earlier. There could be someone who has 10 long-term rentals. That's a terrible landlord and a pain to everybody in planning and zoning. Or there could be one person that owns 10 short-term rentals. That's a great landlord. I've owned hundreds of properties in Jefferson County. I've always taken care of my properties and kept up with them. Yep, the new revision only seeks to invalidate everybody who's gone through the appropriate process. It shouldn't be used. We already have everything on record. A lot of time and county resources have been wasted to address all these things that have already been taken care of. Thank you very much.
Thank you. Is there anyone left who would like to address the topic? In our procedure here for public comments, this isn't a traditional planning and zoning hearing, but I'm going to try to operate it in a modified way. I'll let, if anybody who spoke in favor of the proposal would like to attempt to rebut anything that was said by the opponents, I'll give you the opportunity to do that. All right, that's fine. And if there's no rebuttal, then I don't think probably there's not a reason for the opponents to rebut anything that's said by those who attempted to rebut what they said. So.
Pause for a moment. This isn't really rebuttal. It's really kind of an answer to a couple of things that have been brought up. So I don't mean it as rebuttal, but just on the issue of continuation of a permit that's already been issued, and I just asked our attorney, Mr. Bagster, to verify, in our zoning ordinance, now I won't even bother putting it up on the screen, Division 305, all non-conforming uses and structures, 305010, continuation and maintenance, it says, any lawful use of land or structure existing at the time of the adoption of the zoning district regulations of this ordinance or subsequent amendment of this ordinance may be continued. So for the benefit of everybody thinking that it should be put it into the STRPs, it's in there. Any adoption is actually grandfathers you in, if you want to call it that. So I wanted to clarify that. The other thing I wanted to clarify, there was somebody made mention of relying on the HOAs and the deed restrictions in Henley versus Gadd. We're doing this because we've had a number of homeowners associations who have come to us and said, we got to do something about this, because they then get in a civil battle, if you will, with the use of residential property for commercial purposes in interpretation of that determination by the Supreme Court. So we're here kind of in response to a number of homeowners associations saying, why do we have to do that? Why can't we change the regulations? So I just wanted to declare that it puts the burden on HOAs to have to either enforce or further restrict their neighbors.
All right.
Just those two points of clarification.
Let me ask the court, are there any members of the court that would like to ask any questions to any of those who made a presentation here today?
I do, Judge.
All right.
And I guess my question would be for all of you guys, and I have several. Okay. I want to clarify a few things. The first thing is the information on the permit, and it does say the permit is required to be online and posted with the owner's information. So when you say you're going to change the permit, that information won't be on it going forward?
Can you show us where it says that?
So I'll start answering that question with what it says currently in our existing ordinance. So the existing ordinance says, any advertising or description of an STRP on any internet website must A, prominently display the permit number for the STRP unit, or B, include an image of the permit or a link to the image of the permit in which the permit number is legible. I'll also say that the permit itself, the personal information that's on the permit, and I'm the one that issues these from our office, includes their name, their phone number, and their email address under all the three, whether it's the applicant's information or the responsible party. That's the information that's listed. The other address in the permit currently is the address of the short-term rental property. So that's what's on the current permit. I know we haven't got far enough to, if we're gonna have to redo that application any, but that's what it says right now. I don't know if, hopefully that answered your question slightly.
What this says is the host shall post and maintain a copy of the current short-term rental property permit on the hosting platform and on the inside of the short-term rental property unit in a conspicuous location near the primary door. So the way I read this is if I have a short-term rental, I have to put a copy of my permit on the platform, which could have my personal information on it.
Yes, which is no different than what it says right now in our current ordinance.
No, what it says right now is the
Permit number.
Or the permit.
But we're not given that option in the new one.
Yeah.
Okay.
But once again, I mean, their personal information that's on there is an email address and a phone number. It's not their home address, like I believe was in testimony was given, that it's their personal confidential information. It's their phone number and their email address where they can be contacted 24 hours a day, 7 days a week in case an issue occurs.
Okay, but we'll change that to where it could just be the permit number instead of the actual permit. Okay.
Correct.
There's been a lot of conversation about the 5 items that would have to change that would trigger an expiration of the short-term rental. Change of property ownership, and then change of insurance policy is listed on here. And you guys just said if a property changes, they wouldn't have to do anything. Or if an insurance policy changes, they wouldn't have to do anything. But when I read this triggers the expiration of the permit.
This triggers the requirement that the applicant apply basically for a new license or renewal. So the normal renewal is by December 31st of the year, unless in that 1-year time period, one of these things triggers the requirement for a renewal. And they have a 30-day grace period to file that. So basically, they just file a renewal application with our office to say, one of these 5 things happened, and that's why I'm updating the information that's associated with my license.
Is there a fee for the update?
The renewal application is $100.
Okay. Sorry.
So if I have an insurance change, I would have to come in and reapply for a new permit and then pay $100. But that's what it says because it's change of insurance policy. So I'm just going by what's in the ordinance.
I really don't think that that's necessary when you're just giving us a copy of your policy. It just gets added into the permit, the original permit application.
If you go by black and white, though, it says change of insurance policy. So we may need to clean up that language.
Change that, yes. I think that's reasonable. Let me just explain quickly, there was somebody that asked about insurance policies and does a commercial business have to give us an insurance policy? When we were doing the first short-term rental ordinance, we talked to several insurance agents and just simply asked the question, is there a different type of insurance that they need if they were single-family residents versus a short-term rental? And the answer was yes. And so that's the reason why it was even put in here to begin with, was to assure that somebody who is using a residential property as a short-term rental was aware that they needed to make sure and have a commercial policy. Are we the Better Business Bureau? Not necessarily, no. But that was just something that was added in the very first rendition of this short-term rental ordinance.
Okay. Last question. And I agree that we need to do something, but here's my big heartburn over this whole ordinance. we have lots of legacy families here in Oldham County. You have lots of folks whose parents, grandparents owned large pieces of property. And if I were to inherit that property and decided to put a short-term rental on that property, but I don't live there, then I'm not allowed to do this. I'd have to get a conditional use permit. So, but if we have a manager that's within 25 miles, it's allowed. So why wouldn't we change this?
Well, no, we're eliminating that. It now is related to owner occupied only. That's why we put in, if you live on adjoining property owner, you could do that. So I understand the legacy, and we did come upon this, we had a lot of discussions about that very subject in relation to, let's say it was me, I'll use myself as an example. I have a house in Buckner, and I develop a relationship with Florida, and I start living down there. Maybe I even change my address to Florida, but I'm here 6 months out of the year, 3 months out of the year, and I want to have a short-term rental. Could I do that? And the answer is yes, because I'm the principal owner of that house here in Oldham County, even though my residence isn't here. So there was a lot of consideration about that very subject. And we really just kind of stripped it down to kind of dividing the line between owner-occupied and non-owner-occupied, and said we've got to lay at your feet something. And let me this is a little bit different, but we're talking about the same exact subject matter at Study Review Committee last week regarding minor plats and legacy families and large farms, and how do we do that? We're a growing community, and really we have to start looking at this as a 10 and 20-year policy that we're setting regarding what could happen out in the outer parts of the county, or even larger, small tracts of land that are owned by families. It's an important topic, and we're not ignoring it, but we just have to kind of make some regulation somewhere, make a recommendation.
What would appease me is if we had non-owner occupied property owners, if you still lived in the county, you'd still be able to do that without having to be adjoining property. So if I owned a farm in Buckner, sorry?
No, we don't, we speak from the microphone. We don't answer questions from the audience.
Again,
we'll be given a chance to come up and speak, but we don't
If I'm an Oldham County resident paying Oldham County taxes, I feel like I should be able to have a non-owner occupied rental somewhere else in the county without being adjoined to my
somebody who
current
spoke
property.
earlier said the same thing. I've got two now. What if I was going to go buy more property? We put it on pause. So the question is, because it transfers with the land, somebody could go and develop a bunch of these and then sell them to out-of-town.
So change the language to say if your property transfers, you have to go through the process again. But if I live in Oldham County, I should be able to do it anywhere in the county without just having to be adjoined property.
Let's ask Mr. Baxter, is that a property right or something that could be linked to the owner?
Are we doing this by conditional use permit to get the short-term rental now? They come in to see you all, and walk the commissioners through the current process, Jim.
Well, again, a conditional use permit, it goes in front of the appropriate Board of Adjustments, and it is a public meeting, and then we place conditions upon that approval. And let's just talk about approvals, not denials. And the question I've always wondered is if one of the standard conditions of approval could be that ownership revokes the conditional use permit. We always say that it runs with the land, and it does. And we file a certificate of land use restriction after that approval, so that anybody that wanted to see what's the history on this piece of property, it would be in the deed room, and that would say that the conditional use permit has been issued to this piece of property. And because of that, I think, Mr. Baxter, that's where we always say it runs with the land. But I'm wondering if it would be revoked or the permit expire and not be able to be renewed if ownership changed without going through a conditional use permit again.
it would have to be included on the permit.
As a condition of the approval.
So that the public has notice about it.
Right, yep.
So if, for example, there was a mistake made and it wasn't included on the permit, somebody in your office didn't type it and it gets recorded that way, you know, that would create a problem.
It's still going to expire. It's going to trigger the expiration of the short-term rental property permit if a change of property ownership occurs. That's one of the 5 requirements.
That's the license versus the conditional use. Right, okay. All right, yeah. Commissioner Woosley, that's where Jim talked
Magistrate.
early on. Sorry,
Mr.
Magistrate
Baxter got
Woosley.
wrong.
Yes,
group here.
I heard that, and I'm used to commissioners, but still, Magistrate Woosley. Thank you, Judge. We're talking 2 different things, okay? The first one that we were talking about just a second ago was the conditional use, which is basically saying you're eligible to apply for a license on this property. These 5 triggering events only apply to your annual license. They don't have anything to do with your conditional use.
All right, Magistrate Logston.
Yes, I just need some clarification because this is simple to me. On a non-occupied rental property, did the Supreme Court or Kentucky Supreme Court, nobody's even told me which one it was, did they say that non-occupied rental properties would be considered classified as business entities?
Yes.
And that's simple to me. You can't have a commercial piece of property in a residential neighborhood.
And Magistrate, just to kind of bring that to a little bit of clarity, I have the case in front of me, okay? And it says, subdivision property owners' short-term rental of properties violated deed restrictions, which stated that the property could only be used for single-family residential purposes, that no trade, business, or profession could be carried out on property, and that nothing could be done on property that might become an annoyance or nuisance. One-night, two-night, weekend, or weekly inhabitants could not be considered residents within the commonly understood meaning of the word, or the use by such persons as constituting residential, but rather led to the inescapable conclusion property owners' advertising of rentals rendered his property the equivalent of a hotel, a business activity which was not a permitted use on his lot.
So that was a lot of language, and it started with in their deed restriction in that particular case, and that was brought up by several of the people who were opponents. When I mentioned it earlier, I said it changed the way we looked at short-term rentals. And I also mentioned that it puts the burden on homeowners associations, if there are any in these residential, and sometimes there are not homeowners association. And several of them came to us and said, well, we don't have an active HOA. How do we defend ourselves? So that's essentially what initiated this. I referred to Hensley versus Gadd as kind of one of the triggers of being able to step forward and bring these recommended changes to you.
All right.
My follow-up question on that then is, can the governing body do something that's illegal then?
Well, the answer to that question is no. I mean, if the law provides, the interpretation is that it is a hotel or a commercial activity, then it is considered a commercial activity, which is going to require a commercial or a conditional use permit in a residential zone to be able to operate one, and that's part of. And this is confusing to me too. Okay, so I know we're all struggling a little bit with this, but this is actually, in a lot of these situations, it's going to be a 2-step process because it's going to not be a permitted use in the zone that somebody's proposing it. Mm-hmm. So for them to be able to do that in that zone, they have to come in front of the Board of Adjustments and get a conditional use permit. Just because they get the conditional use permit doesn't mean they meet the licensing requirements. So that's step 2. So step 1 is get the conditional use permit, and if they get the permit, then they have to get the licensing things. And that's why I think it was confusing at the beginning, because we were using permit in 2 different contexts, and it's actually a permit and a license.
Right. And we now ask them to fill out the actual short-term rental permit or license as part of their application for the conditional use, so there's no confusion about what the requirements are in that actual permit or / license.
All right, Magistrate Jeffries.
Yeah, and I would agree with Magistrate Woosley here. I think on this, let's see, E, I guess it is, page 10 of 10, where it talks about if there's any of these events occur, prior to December 31st renewal date, then there'd be basically a $100 fee to change your insurance policy, change a manager, change a property ownership. Those three, I do have some concern with too. Now, the change in maximum number of bedrooms, I think that would be an appropriate, change to where you would charge the $100 for, because that's a pretty big change, and also the status of the previously approved conditional use. But those first three, I think, maybe we need to look at some language that would clarify that they would not have to pay that additional application fee, at the end of the year, say at October, they change your insurance policy, they'd have to pay $100 and then turn around in December 31st and pay another $100.
Right. I mean, based upon the comments from Magistrate Woosley and now from you, Magistrate Jeffries, I mean, the note I had written to myself is potentially amending the language to say a renewal application fee will not be a result of a triggering event, and then we could better define that to say, one of the first three triggering events. So if it's one of the bottom two, that would require an application fee.
Okay. All right, I'd like to ask a couple of questions here, just to add to the discussion. Mr. Bouchard, let me ask you a question, please. And, your wife could come up too, for that matter. We just can't take comments from, these comments that are made from the chairs out here can't get picked up on our video. Sound won't get it. Just want to ask you, you mentioned, did you say you had several different units?
No, sir. We have one.
Just
one
have
unit,
one.
yes.
Okay. All right.
Yeah.
Well, then I need to ask somebody else my question then.
Okay. Fair enough.
I'm sorry.
We want to do it right. One is what we've decided is our
All right.
So.
Well, let me go with Mr. McFarland. How would that be? Okay. I know that you said you had multiple units.
5.
Correct. 5. Did I remember
Yes, sir.
that right? Okay.
I own 5 homes in Oldham County.
Okay.
Some of them are short-term rentals, some are long-term.
Okay.
And I
Yeah,
own-
you have both. Okay.
I have
Well,
both,
we're just
and
talking.
I also have them in Jefferson County and also in Indiana, out of the
Okay.
state.
Short term. How many short term would you say you have?
Altogether, I think I have 5.
Okay. That's fine.
Yeah.
What would you say is the average cost of a short-term rental house?
You mean to purchase it or to stay
Yeah,
there for
to
a
purchase a short-term rental. If you're going to go out and look for a short-term rental, what would you say would be the average reasonable cost that you'd be willing to pay to get it?
Oh, well, that varies based on it's still like a real estate, right? If you're looking for a 3-bedroom, 1-bath house, which is one of mine in LaGrange, I think I have the property tax bill just came to me, so it was 180. No, it's probably 210,000. Another property I own is probably $1 million. So I mean, it just depends on what it is.
Short-term rental.
A short term or long. I mean,
I
don't fully understand the question.
I'm not
I don't
trying to trap you in some type of question here, but I remember you said that you had rented one of your properties had 1,000 renters, short term.
Yes. So my farm, I have welcomed over 1,000 guests.
Okay.
Over
So
the course of
it wasn't
time. Obviously
okay.
not. Yeah.
That's a farm somewhere
Yes.
versus a house on the street.
Yes, but these, if you turn to the one section, even an agriculturally, AG1 is on this chart here,
Yeah,
anything that's residential, it says not permitted. So no conditional use, and then obviously if you can't get a conditional use, you can't get a short-term permit or license. So one of mine falls into that category, and several of my others would just be residential.
So,
like
I mean, when you
like
had
a home.
1,000 people, there were multiple people, 20 people showed up at once to be in at the
Yeah,
farm
over the
or
course
something
of
like that. Yeah.
nearly 6 years, if you look at my reviews, with an average of anywhere between 8 to 12 people, it's been very successful. And so my point is it hasn't harmed anybody, but this ordinance directly harms me.
I think, and I'll just speak for myself here, my perception of this is what people in the community are fearful of, and I'm sure that you're aware of it, and Mr. Guillory and others were, I live on a street and a house. I don't want different people showing up, driving in the driveway next door to me every week. I don't know who they are, what they're about, where they're from. It's a disquieting situation. You got a farm out in the country and it's not bothering anybody, I don't care about that. But I certainly don't want 300 different people showing up, moving in a week at a time next door to me all year long, year in, year out. That's a concern I have personally. I've also had property for sale in the last couple of years. I was bombarded with calls, people wanting desperately to buy my property. Is your house for sale? Well, blah, blah, blah. And I read in trade magazines or somewhere that large conglomerates are scooping up lots of, let's say, inexpensive houses, trying to get a corner on the rental market in the future, doing something that is going to eliminate, let's say, affordable housing for certain people. I don't know who you would say is your average guest or anybody's average guest in a short-term rental, but Ms. Hyde said that we need more short-term rentals because we don't have enough hotels here. To me, it seems to me the more short-term rentals we have, the less opportunity we're going to have any hotel here, because there's already, the market's getting soaked up. So those are things that are in my head on one hand. On the other hand, I don't want to be a guy here that sits here and takes a good business opportunity away from you or anybody else. I agree, you're not hurting anybody, you're not damaging the environment. It's just kind of spooky to let people buy up neighborhoods. Somebody's got 5 houses on one street on Riverside, they said. Well, that's, I don't know. I don't want 5 rental houses on my street, honestly. It's not my business, but I do live there, and I'm concerned about who's walking around and who's showing up. So I think this is part of this whole mix of what we're trying to struggle here with. And,
I think that one of the comments that I suggested is that to combat that is really, and I think a big problem can come from outside entities coming in to buy, and that's happened all over the nation. That a large company, BlackRock, is one of the largest rental companies in the world, I think, and they buy long-term, short-term, and there's other companies that just concentrate on one or the other. And so that buys up homes in our communities, that takes out personal investors, takes out the opportunity for just regular residents of the community to buy and sell. So I would be in favor of a limit like that, and that's why I suggested, that would be one basic thing. But in terms of like the type of guests that we have, I went through a kind of a long list of the types of guests that we've had, and some are, actually, I would say all of the guests that come through my short-term rentals, they do that because they want to stay in a home. They don't want to stay in a hotel. So why has this been such a successful enterprise across around the world, actually, like say for the Airbnb platform? It's because people like to stay in a more local environment. So, for example, in all of my places, they have a kitchen. So they can make their own meals, their own dining, if they have specific dietary, whatever. You're not having to go out, spend money in restaurants or hotel. So the types of guests that we have are respectful, and they want to stay in a home. So that's why they stay there. The polo player, for example, He wanted to be out here, even though all his polo contests were at Oxmoor Farm in Louisville. But he chose to stay out in Oldham County. The person that took care of his horse and one other caretaker was with him, so 3 people. So, I mean, the complaints and the issues of certain places, I think, should be dealt with as opposed to a sweeping countywide, provision. And the other question I wanted to ask was, were any current non-owner occupied short-term rental owners asked to be or invited or were even present at any of this, the planning meetings? And then if not, I just wondered why. Because that would have been someone else mentioned, that would have been a much more appropriate way to address concerns and to draft this, as opposed to it literally is quite personal. I know there's a grandfathering clause and things like that, but this prevents me from, buying another farm or another a 10-acre piece of property and doing this, as well as restricting in a neighborhood. So it's just too overreaching, I think, for our government to do at this point.
All right, thank you.
Do you have any other questions?
Anybody have anything they'd like to add? Magistrate Dye?
What we've got here is sort of a conundrum. We have a group of people that want to eliminate the situation, and those are the people that have probably in their neighborhoods have had what we've decided to call bad actors in their neighborhoods. Now, are the people that live there bad actors, or are the owners of the property just not good actors, put it that way? And then we have a second group here of some people, yourself being one of them, that know, and as Kim, Miss, I still want to call you Miss Buckler, I'm sorry. She said that you guys are doing it right. So you got two opposing forces here. One, keep it this way, and that'll make my life happier. Or we have the other force is want to get rid of it, and makes their life happier. And I'm a HOA president, and I can tell you right now, you can't lay this at the feet of the HOA. The HOAs do not, for ones that are functional, and the one I'm in is functional, the only way we can get people to behave themselves outside of the violation of county ordinance or state law, of course, is we've got to take them to circuit court. And I don't think you need to put that burden on an HOA to say, well, every time you get a bad actor in a short-term rental, and we got to spend $50, $60, $70, $100,000 to get it straightened out. And that's not right. This has to be at the county level, and I agree with that. So I understand there was a position, someone said that they just heard about this through, I forget which, it was a young lady said that, she just caught this at the last moment. That may be true. At this point, I would vote to eliminate for the sole reason and give you guys an opportunity to, Mr. Baxter, you said that if we vote this today, that eliminates everybody in the room from having these short-term rentals, correct?
No.
Okay, that's what I thought you heard. Then I said, well, no, he didn't say that.
No, and Mr. Urban read the provision of the zoning ordinance that indicates that non-conforming uses up to this point are grandfathered in. So anything that exists and is legal today would be legal after the passage of the ordinance.
Okay, so
anything after that would have to go through the new process.
Okay, well, so that would be, so taking what you just said, everybody is, that the ones that, as Kim Buckler has said is doing it right, you're not going to be harmed in any way. Now, your way you're going to do business in the future is going to be a little different. But on the people that have said they've got bad actors and have problems, they're going to be helped. So it's going to be just the way it is. I can vote this in and leave a guy like you and the rest of you, the other 10, 12, 50 people, or the 21%, whatever you said it was, you're not going to be harmed financially. Would you agree with that?
I don't think
at
I
this,
would.
at this point in time?
Well, I have a current conditional use application in process for the first hearing on October 19th, I believe. So if you vote that, then
Well,
then
I can't speak for what, you don't have it today. Now, if it's
Right,
in the
if I don't-
process, does that count? I don't know. That's going to have to be something
Yeah.
outside my purview, okay?
Well,
I'm just-
and I hate to interrupt, but you have a pending application. First of all, if the ordinance is adopted today, there's a period of time, an appeal period, that is allowed, a 30-day appeal period. So it wouldn't become effective until that appeal period expired, number one, and might not become effective if somebody were to appeal after that. But we had this discussion at the Board of Adjustments a week and a half ago where there was some discussion by members of the Board of Adjustments about whether or not they should table an application. And I told them they could not table the application because the law that's in effect that applies will be the same law that will apply to you at your October hearing.
Okay, so what he just said. So I think now if there's something, and I'm sure that Mr. Urban and his people who worked diligently on this, I believe that those of you in the room that feel that have already been said that you're doing it right, and I don't have any reason to doubt that you're not. You know, I'm a firm believer that ordinances and laws and stuff like that, when they're made in these rooms, I think there should always be an oversight period. You come back later on and say, okay, did we take too big a bite? Did we take too small a bite? I think that's the time that you guys can get with those guys and make something that you got today that you don't necessarily agree with, but it's not going to necessarily harm you. And where you're going to, and the other people are going to get helped. So that's why I'm going to vote. I would vote to vote this in, and I think it's the beginning of a good way to get it right. You know, but that's my position on it. But I think you just got two opposing forces here. It's kind of like some of you guys are wearing white hats and some of you guys are wearing black hats. I think it's not that difficult. So anyway, I think I've got that right, and if I didn't, I'm going to apologize now. Thank you.
Yeah, I just want to comment to follow up with that. I would think that all the effort that's gone into this was significant, and it just didn't include a significant, people that are involved in that. So I would say that was, not handled correctly. I think that would have been come to a better conclusion have we been involved in the process of that, because I don't know if any of you have stayed in short-term rentals when you've gone to places. Have any of you, I mean, Airbnbs, VRBOs, I mean, does anybody have that experience? Or
Yes.
is this being made by someone who, by people that don't use this type of, what do you call it, accommodation?
I have stayed in short-term rental in Florida, and it was actually, office building isn't the right word. It was some type of building that was built specifically for that. I mean, it was, in somewhere down there, Destin or something like that. And it wasn't. I didn't stay in anybody's neighborhood. I was in basically a commercial building, I guess, but it wasn't a hotel. But it had a kitchen and it had everything else, you know.
And I think to address the issue, if there's specific problems with a property or a section, and if it's not a homeowners association, they don't have one, or it's too big of a deal because of, you say, the financial part, then the conditional use process or the annual permit is the way to remedy that. If you have a problem client, so to speak, or whatever, then you don't renew that. So that's is a very simple process to alleviate all of that. And so it's going to make me even more, due diligence and responsible to make sure that I make sure that the guests that I have behave. And I've turned down guests. I don't have to accept every guest that comes my way, because if I see a rating and they said they weren't so clean, I mean, I'm kind of picky. So I say, I don't want you to stay in my place. So I have turned down guests. So you have the opportunity with the current process to just not renew someone's
I think
permit or license.
I may be wrong about this, but I believe you're making what I'd call a granular argument. You're right down at the nitty gritty. In the back of my mind, I don't want BlackRock to own 1,500 houses in our county 10 years from now.
I don't either.
No. And I think that's part of what has a lot of people scared, you know. I'm not afraid of you because I think you do a good job, but I'm afraid of them.
But you know,
'Cause they won't care. They won't be here. They don't care about anything except Chinese money.
to take that point, and just one last thing I'll say to you is what you just said there. You know, you're acting as the gatekeeper. Okay, the ordinance is going to act as the gatekeeper for the people that don't do it the way you do it. I commend you for the job that you do, and the rest of you that do it right, according to Kim. That's great, but I'm also concerned about the people that, you know, maybe I'm not going to say they're not good businessmen or they're businesswomen. They you know, I've had situations with people with rental property, and I'm talking long and short in my subdivision, and I can't use the words that I've been told about it, what I could do with my problem, in front of this microphone. So, you know, I have to, you know, I'm not using that for my vote. But after I heard what you said, and they said it's an opposing battle, but basically both sides are going to be helped. It's going to make it better. And if we pause this, then you're going to have a lot of people going to run out and try to get conditional use permits. You know, people want to get, you know, always want to slide in under the wire.
I mean,
that's all I got to say about it.
During the conditional use process, I believe there's the ability to decline that. So mine is in for review, you know, in a few weeks, and I suppose I could not get granted it. There's no guarantee that I'm going to get it. So I don't think that just anybody that can put this in, if you have someone that's, I don't want to pick on a state, but let's say California wants to pick up some cheap Kentucky property because, you know, it's a lot cheaper here than in California. So you could restrict that, especially if you just had something in there that says you have to live in Kentucky. I wouldn't restrict it to Oldham County because some people might have to leave the county for various personal reasons, and yet you still own property in Oldham County. So it needs to be Kentucky who are invested in Kentucky, this area. But I don't want BlackRock buying property down Sunset Road where my mom
They'd
used to live.
contest your argument with the Interstate Commerce Clause or something. You know. Okay. Thank you. Magistrate Hounds.
Thank you, Judge. My question is to the staff. So I'm trying to put my head around the number of people that you're going to allow in the unit. Is that some kind of standard? Where did you all come up with this number of people that can stay in a unit?
Chris, are you doing like two bed times bed? Yeah, that's crazy. That's like a college hotel room.
Plus 4.
That's the magistrate hounds. I almost said commissioner judge. Magistrate hounds, that's in the existing ordinance now. So that's one of those things that was carried forward from the 2019 ordinance that seems to be working well.
Okay. It just seems, you know, I'm thinking of a couple of places that I know are Airbnbs, and that seems like a lot of people to put in some of these houses. I mean,
yeah. Well,
I'm looking at it from the
right
egress and
the other thing though, where we have strengthened that is that the number of bedrooms is not defined in the old ordinance.
Okay.
Where we said, you know, the number of bedrooms is this, and your maximum capacity is this times that number of bedrooms. Where prior to, if this ordinance gets adopted, again, someone could say the pull-out couch is a place to sleep, the futon's a place to sleep, the basement is a place to sleep.
Okay. And then just a general comment to the audience about notifications. I don't know how you do notifications and make it work. It wears me out because we have Smart 911, we put out notifications about things people complain about. We put things out on Facebook. We put them out in the Oldham Air. We can spend a ton of taxpayer money putting out these notifications, and inevitably somebody's going to come to us and say, I was not notified. I don't know how we make the notifications correctly. I don't know if the notification process, if there would, during the TRC and the other meetings, if there was adequate representation between the two groups. It doesn't sound like there necessarily was adequate, but what is adequate notification? What is adequate number of people to show up to each one of those meetings? I don't necessarily have the answer to that. But I do think, though, that one of the things we've brought up is we're trying to make it so that people that have property in a residential area are not adversely affected by what's going on with their neighbors. Now, I can give you an example right now of a neighborhood that is, I know it's not a short-term rental, but that neighbor is not taking care of the property the way that another neighbor is. So that's a big debate that we can have, whether it be a short-term rental, long-term rental, or a person that actually owns owner-occupied piece of property. That's why we have code enforcement. You know, we task code enforcement to go out to these individual properties and make sure that they're being taken care of to the best of the ability of the homeowner. And if not, hopefully try to help them out. The comment that was made about Kentucky residents and Oldham County residents, I think that's something we may need to look at, or how do we explore that? I'm kind of torn between that, because I see where we want to try to promote business, we want to try to promote Oldham County, and in some cases I've heard, I didn't think about until it was brought up, that we are promoting Oldham County through the short-term rental process, that people are coming to Oldham County. Maybe they're seeing it for the first time, and maybe they're going to come back and enjoy some other amenity that we have, or for that matter, maybe they're going to decide to move to Oldham County and make it their permanent resident. We do have a lot of property that is owned by individuals that is their 401k, as some of us like to call it. And, you know, are we restricting an Oldham County resident from being able to use their property if it's properly zoned, I guess? But, you know, again, you go back to the agricultural piece, there's a lot of property that's zoned agricultural that's going to fall out of the loop. Could they get that piece of property? And I didn't look at the list. I just thought this. Can they be AG2? Does that make that? No, it doesn't work in AG2, does it? Okay. Because that's agribusiness. Seemed like that may be a flaw in your plan, Jim.
We don't have any property zoned AG2. That was created for the potential of distilleries and craft breweries, and so there is no AG2.
Well,
but all of them on that list are conditional uses by owner occupied. So they're permitted in AG. I'm not sure what your question is after that.
Oh, okay.
Magistrate
Okay,
Hounds.
I think
We'll talk.
Magistrate Hounds, I do know one thing that you can know that works on notification. When school's going to be out because of snow. Everybody gets that notification.
I feel like the court has aired this out as well as we're going to be able to, and we're probably reaching a point of diminishing returns here. Is there a motion that we adopt this ordinance changing sections 250 to -50 to what is recommended by the Planning Commission and the study review?
Judge, I'd like to make the motion that we adopt, we repeal and replace section 250-050, short-term rental property of the Oldham County Comprehensive Zoning Ordinance.
I'll second.
All right, moved and seconded. Do we have further discussion among court members? Magistrate Jeffries?
Just a question. I know we had some discussion earlier about E on page 10 of 10, about adding some language that would not require, if there was a change of property ownership, change of manager, or change of insurance policy, that they would not be required to pay an additional $100 to reapply for an expiration. Can we add that language in there?
Yes.
I think that the movement has got to adopt that change, but yes, you can add that language if the movement is okay with it.
Magistrate Hawkins, will you agree to that adoption?
Would you state what it's going to read now?
Yes. Yes. A renewal application fee will not be a result of a triggering event that's caused by a change of property ownership, a change of manager, or a change of insurance policy.
And I think we talked earlier about it just being the change of insurance would be the one to not trigger it. Otherwise, it would fall underneath the grandfather law, right?
It would not require a renewal fee, but it
Gotcha.
still would require them to file the paperwork with our office to signify that change.
I'm agreeable to that.
Okay.
Okay, good.
Magistrate Tice?
The only thing that I'm reading in that, and correct me if I'm interpreting it wrong, is that if you had to renew it because, or it would change it being permitted if I just changed the insurance company. So now does that mean that if I have a short-term rental and that I decided to change insurance companies, that I have to go back and reapply to get it as a short-term rental again?
No, but you do have to file basically an amended license showing that you have changed your insurance.
So presently today, if I have a short-term rental, there's a conditional use, right?
We're talking about two different things again.
Okay, well, that's what I'm afraid.
Okay, so there's a conditional use permit, and then there's a license. So as a part of the conditional use process, the office requires that somebody submit the license information with the permit. But those are two separate things. You have to renew your license every year. The conditional use permit runs with the land. It's a one-time fee to get the conditional use permit, and then it's an annual fee to get the license. What you're asking about relates to the license.
Right. And that's what I wanted to make sure, that
Yes.
it did change the conditional use to do that.
No, sir,
I
it does
understand.
not.
Okay, I'm clear. But I wanted to make sure this said the same.
Magistrate Hawkins?
Okay, Brian, or
Yes.
we can talk amongst us. There was testimony by somebody named Steve regarding the fire pit situation. I wonder if it would be appropriate on that last bullet point under number 10 to maybe preface that line that says outdoor and group activities shall not occur during the hours of 10 p.m. to 7 a.m. Would it be appropriate to put the word obnoxious or a synonym to the word obnoxious? Or is that too subjective?
That would be subjective.
Too subjective?
Because what's obnoxious to you may not be obnoxious to me.
But
Well, why don't you say, you could say that unless the activity, we could stretch the hours, but say they have to maintain the nuisance. We have a nuisance ordinance, so you can't do just anything, anytime, anywhere. Anyway, so why can't you, if you want to give us some leeway on that time period,
Okay.
say that,
So, no.
We could move it back to 11 or midnight. I don't care, as long as it doesn't violate
The
nuisance ordinance. The police are called.
Okay.
They,
So I like the 10 to 7. I think that's okay. So maybe we could preface it with something along the lines of activities outside or activities in conflict of the nuisance ordinance shall not occur during the hours of 10 p.m. and 7 a.m. You agreeable to that, Jim? Okay.
Is that repeat that, please?
Well, what it was real simple, it's activities that violate the nuisance ordinance shall not be conducted between 10 p.m. and 7 a.m.
They shouldn't be done at all.
Well, they shouldn't be
right.
done at all.
Right.
Right,
But
But then that leaves it less
Why
subjective.
don't you say that the short-term rental, let's stretch out the hours on the time the property can be used unless the property is in violation of the nuisance ordinance. Say it can go to 7 a.m. to midnight. If they want to sit at the, the fire pit, who cares, as long as they're not, a band playing in the backyard at 11:30,
Right,
Isn't that what you're trying to accomplish?
right. The testimony regarding just sitting around a campfire, if this says outdoor and group activities shall not occur, that's pretty absolute. So if we, instead of saying, limiting it to an absolute shall not
You
occur,
can say outdoor activities are permitted between 7 a.m. and midnight as long as they do not violate the nuisance ordinance. Wouldn't that
yeah,
accomplish
I think that's
that?
what activities that violate the nuisance ordinance are not allowed between 7 p.m. and,
No,
or
you
10
can't say
p.m.
that. You can't say that because you're allowing people to violate the nuisance ordinance.
I'm not sure there's hours associated with it. Is there hours on the nuisance ordinance?
Yeah, based upon what I heard, let me run this by you guys.
Sure.
Outdoor and group activities in conflict with the nuisance ordinance shall not occur during the hours of 10 p.m. to 7 a.m.
Thank you. That's what I was trying to say.
Do you
You can't do that.
No.
Okay.
That's not what you're trying to
It's
accomplish.
not, okay.
Why don't Brian and Jim, let me make a suggestion, see if you'll accept it. Outdoor activities are permitted from 7 a.m. until midnight unless in conflict with our nuisance ordinance.
But what
Put
they've
it on
said
the
is
positive.
the nuisance ordinance isn't necessarily defined as being time restrictive.
Well, this is, though.
Okay,
The neighborhood backyard activity is restricted in short-term rentals between 7 and, let's say, midnight,
yeah.
unless you're permitted, let's put it that way, unless you're, put it on the positive, you're permitted unless you're in conflict
Of the
with a
nuisance.
nuisance ordinance.
Okay.
Then we have to shut you down anyway.
Brian, did you get that language? I did not. You're flipping, okay.
I'll repeat it one more time. It's not that hard. And we'll see if it's approved by accepted by you and the second. Outdoor activities are permitted between 7 a.m. and midnight so long as they are not in conflict with the nuisance ordinance.
I accept that regarding my motion. And Magistrate Likens,
Are you making your motion with those two changes?
yes, but I'm not done with my questions.
I understand what you're trying to do, Judge.
But
I
so
think it's
far.
kind of in conflict, and I guess I'd ask Mr. Baxter, let's make sure we cut the language in there correctly, that we're not backing ourselves up into a corner. I think I understand what we're trying to do, but I struggle with your language. And I'm going to give you, you are a better wordsmith than I am, hands down. I'm not going to.
Well, what is your conflict?
What's your
What is your issue?
suggestion?
The question is, how long can we permit short-term rentals to have outdoor activities in a neighborhood? Set a time limit on it, but if the outdoor activities are in conflict with the nuisance ordinance, they can be stopped at any time between 7 and midnight.
But the time frame doesn't matter with the nuisance ordinance, it's 24/7.
No, we're not talking, we're talking about the time frame for the short-term rental activity. Okay? Otherwise, if you're not in conflict with the nuisance ordinance, you can be sitting in your backyard at 3 o'clock in the morning burning your fire pit, if you're not in conflict with the nuisance ordinance.
Right. You can carry on quiet activities. Pardon me?
Well, I'm trying to say, if you, under what Magistrate Hounds is saying, you could be in a short-term rental at 3 o'clock in the morning, sitting around your fire pit, as long as it's not in conflict with the nuisance ordinance.
Right, so quiet
Most of the
outdoor
nuisance
activity.
ordinance has to do with making too much noise.
Mhm.
No,
No, we're discussing it
we got a
in
motion on the
Okay.
floor. And
Okay, Judge.
We don't want to, let's not go down a rabbit hole with this.
Okay.
We're just trying, your suggestion is that we allow more flexibility on the activities, and that's
Right.
fine as far as I'm concerned.
Yeah.
As long as they're not doing something that would be in conflict with the nuisance ordinance during those during that short-term activity approval period, outdoor approval period. Magistrate Hounds doesn't think that makes sense, but does it make sense to everybody else or not?
Judge, I guess my question, so that I can understand this, is, and I'm not necessarily looking at the right slide here, but on what was distributed, the language is outdoor and group activities shall not occur during the hours of 10 p.m. to 7 a.m. Is that the particular part that we're grappling with?
Yes, sir. That and so if somebody would like to have a fire at the fire pit and they're quiet and it's 1 a.m. with the wife and the husband, I think is the
Not 1 a.m, well.
Should that be allowed? I think that's okay because they're not. Whereas this is an absolute shall not occur.
The word shall is what's killing.
So I'm trying to offer flexibility for the romantic evening, like Mr. Steve offered in his testimony. I think this is among the magistrates right now,
We do not accept comments
though,
from the
'cause
floor,
there's a
Kim.
motion on the-
Kim, we're not debating back and forth from the floor. If you want to say something, you can come forward, but I'm not taking any comment. And
but-
we're not going to, I think, I see 3 or 4 people saying, we're going down a rabbit hole. Let's stop this right now.
So with the
okay?
motion
Come
on the floor.
We got a motion on the floor, and we're going to take a vote. So no more clarification, please.
So,
Okay.
just to turn this a little bit, what if we said that the applicant had to establish quiet hours? Instead of trying to decide
I
whether
think
you can grill or
we're
not
getting
grill.
too fishy here. Can't we come back and amend this later?
Yeah, we could.
I mean,
But I think just
I think
establishing a
what
quiet
Magistrate
hour.
Hawkins was trying to do was just expand this 10 o'clock a little bit.
Mm-hmm.
I don't know why it's so confusing to let it go a couple more hours and
Well, I think, Judge, what I'm hearing is I'm sitting out around a campfire and it's me and my wife, and
Yeah.
why can't I do that? As opposed to saying, you can do that. It's just the house rules have to establish quiet hours. And then the applicant is the one who gives us those quiet hours. And they say, look, we don't want noise out here anyway. So we want to establish our house rules that they would enforce between whatever.
Well, they
11
enforce them. That's the problem. We don't enforce it.
Well,
Just like we don't enforce HOA regulations, we're not going to enforce rules for a homeowner for a short-term rental.
Judge, what about the language of, instead of using the term outdoor and group activity shall not occur during the hours of 10 and 7, why don't we word it something like quiet hours should be recognized between the hours of 10 and 7? And you can still have your quiet
It's fine with me. I give up on it.
Judge, I think we're just going down a rabbit hole here, and as was pointed out, and it's like making sausage. They relate to that, and I think if this is not working, if we pass this ordinance today, and it's and something pops up, and hey, this is not going to work, they can always come back and we can modify it. But I think we're going to be here till midnight if we don't come to a vote here on this. And I think we need to go ahead and see where the court is, and if there's enough support to pass this ordinance as been amended, then let's move on. That's my suggestion.
So you'd like to leave that last line as is?
So do you call the question?
No, hold on. Okay, and then somebody else had made in part of their testimony, the statement of privacy out there, and I get that. Number 10, the second bullet point, states the name of the host, their address, the email address of the host, and their phone number needs to be posted. I think it was in the unit. This one, number 10, doesn't say online, but it has to be on the property and available for the transient guest to use. I'd be okay with taking that second bullet point and just having the name of the host and their phone number as a backup in case the manager, which is the first bullet point, is unavailable. And strike the part that says the postal mailing address and their email address of the host. Is that favorable to everybody? The first bullet point does state the manager and their mailing address, email address, and phone number, and she could be reached 24 hours a day. The second bullet point actually says the owner, and perhaps that address and email address could be struck from that line and just leave it as host name and host phone number.
Why don't you just put it together and say the manager and owner?
Well, because the manager could be different than the owner.
I know, but both their addresses all have to be there. The manager and the owner's
That's how
address
it's
and
written.
Blah, blah, blah. Well,
That's how it's written.
That's all you need.
But then there's the privacy portion of now the owner's address is now posted in the house.
It's a matter of public record anyway, in most cases.
Well, I'm just trying to help with the privacy issue because that's an important issue.
Judge, do you want me to read back what was proposed?
Okay.
All right. The name of the host, and telephone number in which the host may be reached on 24-hour basis, 7 days a week.
Language instead of the whole,
Right.
the name of the host, the postal mailing address, the email address of the host.
Yes, no
the
postal
telephone.
mailing or email address.
So just strike the postal mailing and email address.
Right.
Is everybody favorable with that?
Was that your motion?
I would change that if the man who seconded it would be
All right, you-
favorable.
I'll amend her motion with those three changes.
You agree to the
Those
amendment?
three changes,
Is
okay.
there a second?
Second with those three
All
changes.
right, so we basically have a motion to approve these changes with the managerial, the information section changed and the $100 fee dropped on 3 out of the 5 categories.
Yeah, I just want to make sure that was clear, because I think Magistrate Hawkins just said insurance. So as long as we're okay with the first 3 that are listed here.
Right.
I'm okay with that. Magistrate Likens?
Right.
Yes.
All right.
Judge. Question, Judge.
Yeah, you.
To our county attorney, do these changes make enough that we'd have to go back to the cities?
I don't think so.
Okay,
Well,
thank you.
the cities are going to have to adopt the ordinance separately. So the only other thing, Judge, is that Magistrate Hawkins has referred to the section of the zoning text amendment, and I can't read it, but in the bottom right corner is the ordinance number that also needs to be incorporated into her motion, please.
Which one are we?
The KOC number.
Okay. And tell me what I'm doing. So I read that and that's,
You're incorporating that number
Into that, okay.
Yes, that's the ordinance itself. That's
I'd
the
like to, as part of my motion, incorporate this, shall it be adopt, into KOC 23-920-391, please.
Second.
Thank you.
Just a clarification.
All right.
If we were to turn this down today, would it go back to planning and zoning for them to then review all the comments?
No. Go ahead, Mr. Woosley.
I'm just saying.
No, we're incorporating what we're doing here. So,
If it passes, I understand, but if it fails, does then it go back to planning and zoning and allow them to take into what we were discussing today?
Magistrate Woosley, we would have to start the whole process over, and this has been ongoing since April, so we would probably be looking at a similar timetable.
I'm not sure which comments you're referring to. All of them? Okay.
Yes, we have multiple comments from the audience that didn't have participation, and then comments from magistrates.
I guess we'd have to go back to the study review committee, like Brian said, and start from the beginning.
Thank you.
all right, we've got a motion and a second on the floor to change the number, whatever it is back there.
We have a roll call vote, Judge.
Yes, sir. Okay. You want to call the roll, please?
Magistrate Hounds.
Yes.
Magistrate Logston.
Yes.
Magistrate Tice.
Yes.
Magistrate Woosley.
No.
Magistrate Hawkins.
Yes.
Magistrate Dye.
Yes.
Magistrate Likens,
Yes.
Magistrate Jeffries,
Yes.
Judge Vogel.
Yes. All right, motion passes 8-1.
Judge, can we take a recess?
Oh,
Yes,
wait,
we'll
hold on.
take a 10-minute recess, please. Huh? What'd you say, Magistrate Dye?
Motion.
Second.
Is there a motion we go back into session, please?
So moved.
All right. You tape one down when you made your motion there.
Judge, I'd like to move the coroner's portion up to this time now. He has a pressing issue he needs to get to. So
Okay.
this is the coroner, David Pendleton, as we all know him. He has put together a what to expect when death occurs brochure. It was brought in front of the Public Safety Committee today. It was voted out to a vote for 3-0. So I asked the coroner to come today and explain it to the court for those who may not have read it too closely in their packet. And so, David, you got the floor.
Thank you, sir. I appreciate you helping me with moving it forward. A lot of these questions that have come up in my office about folks, when they do have the worst day of their lives in some cases. So we kind of tried to put together a little booklet / brochure to hand out to different entities in the county. I've worked with my chaplains to help with the death notifications. They're also going to help with trying to get it out to some churches and places like that. Just something a little more informational to folks that they don't always think about when the time happens that they're confronted with us, and we just trying to get some more information out to the general public to answer some of the questions and hopefully move forward with a lot of issues that they've had with trying to get a hold of us and things like that, or they forget during the situation that they're trying to deal with. So in the brochure, it talks about several different items that are prevalent or that have always come up, and again, it's just trying to get more information out to the public.
Okay, thank you, David. I'll make a motion to approve this brochure that David's prepared for his office.
Second.
All right, moving second. Is there any discussion?
I looked at it and I thought it was excellent. Thank you.
Thank you. Great. Thank you.
Judge.
Magistrate Hawkins?
I know, I would agree with Magistrate Tice. When I review some of these things, I look for the content. Would you like me to wait? I review the content and the grammar, and I thought both were spot on. My question is, okay, you get to the page about funeral home information. And so as I was reading this, I was under the impression this was something that you were giving to, say, a family when you're there in their home at this time or something like that, where you can kind of say, here is, it talks a lot about autopsy and things like that. So here's my question. When I'm reading through that and I'm kind of feeling the empathy and compassion of the person writing it, I get to the funeral home page. Okay, that's good. I would have liked to have seen this now new section with the medication take back be a whole different brochure. And I'll tell you why, because I got right from that just warm, like compassionate brochure to this other one where it states that I could be a drug dealer if the person maybe died in my household that was, maybe got a hold of my drug. Like it kind of was like, oh, it took me back a little bit. And I thought that should maybe be its own separate brochure if you're in a home or someplace where that kind of information may need to be presented, but not necessarily with the other stuff.
And I thank you for looking into it like that. But what we do is we get on scene. We're compassionate enough to understand what's going on. So all this is explained by us at the time. This would be a brochure that'd be sitting out somewhere if you wanted to read about it, or we talk to someone that has, hey, I've got an elderly family member, and we're just trying to get prepared. Then this would be beneficial. But as far as the scene itself, we're explaining things, what's going to happen and all that. We're trying to make sure that they understand what is coming up. So to leave this, when we get ready to leave, that might be something we'll do as far as if you have any other questions or thoughts afterwards. Because again, with the families, we're dumping a lot of information on them within an hour or so, of waiting on the decedent to be transported and things like that. So a lot of these questions come up. We're trying to get information out that will keep them from having to call us back with, hey, I don't know if you explained this, but this is what I've got, or what can I do about that? So these things are guidelines that coroners do on a regular basis. And this is just information that they might have in the afterthought of to say, you know, what do I do about this? Or should I have given you this? But medications and things like that, we're going through those opiates and that as first, you know, right then. I'm running them through Casper to see, you know, if anybody does have opiates prescribed to them. So we can take possession of those now. Part of the Coroners Association was to step up. Our part of the opiate crisis was to try to get those things out of the home at that time to prevent any other family member from doing that. We also notify, you know, pharmacies that they're deceased, not to get those prescriptions filled. Now, we don't do that on everyone, but there's some situations, and I think, you know, common sense steps in to say, well, we probably need to let everybody know that, you know, these medications are taken, you know, at the home and things like that during that time frame. So, you know, it's all played out with the situation that's presented to us. And I feel like my deputies, you know, we step up to notify them verbally, you know, communicating with them. We all kind of get a mindset of what's going on. We're reading the room, you know, and then we're going to leave information. Same thing with the suicide pockets that we have, you know, the booklets and things like that. Nobody wants to talk about it right then anyway. So it's just kind of like the afterthought to say, you know, in case you have any questions later, you know, that's what a lot of this comes from as far as me handing it out. Again, it's something that we can put out in public meetings or, you know, elderly, or not elderly, you know, our older groups meetings and things like that, you know, that they might be able to just say, hey, in case you need to know, you know, that type of thing. That's
Yeah,
really,
like our senior event that we had.
right, those type of situations, not saying, you know, that they're the, you know, but that's just calling it what it is. I mean, it's, you know, being realistic.
To the
you know, with
various
folks.
demographics.
Yeah, to prepare family
Okay,
members.
so then are you saying then when you do leave somewhere, do you have information that you can leave them with the local funeral homes and all of this other stuff about?
No, man, we take care of that right then and there. We don't, I mean, we're examining the situation and trying to make it as fluid as possible to reduce the impact. And that's our help, is to make sure that they know they got options. We talk about direct cremations. We talk about funeral services. Where's the majority of your family from? You know, what area they might be thinking about. I'm not funeral home affiliated at all. So we give them options and make sure that they understand, because again, a lot of this is catching them off guard. You know, the reason why the coroner is there, it's a situation that is a coroner call. So that means that it didn't happen. They weren't anticipating it or things like that. So we know that they're going to have a lot of questions and stuff. And we try to resolve that issue right then and there with funeral services to try to see who they're going to contact. And if they don't, then we, you know, call company and have them held until, but we're in constant contact with them.
So then are you saying that you also go through like the necropsy or the autopsy, necropsy's animal, the autopsy information while you're there in the house?
Yes, we let family members know where their loved one's going, what type of care they're going to get, and, you know, how secure it's going to be, and, you know, just trying to decrease the situation where they understand, you know, that they're going to be taken care of.
Okay.
But
Thank
in
you.
case it happens beforehand, at least now, if you read my brochure, you'll understand why I'm going to send them for autopsy, or why I don't send them for autopsy.
Right. Okay. Thank you.
All right.
Judge.
Manager Woosley.
Mr. Pendleton, do you have money in your budget to print this, or are we
Yes.
going to?
Yeah, we anticipated this coming.
Okay.
Mm-hmm. Thank you. And that's being done right now. We're looking at, I'm relying on someone a little bit more educated to lay it out and make it flow right. So, yeah.
Manager Jeffries.
Just one quick question as far as the printing. Do you, how many copies do you plan on printing, and do you update this yearly or every so many years?
I haven't really looked at that number yet. We're getting a quote for it to see what it's going to cost, and my anticipation is about 500 copies or so to start out with, and then we'll see. But yeah, I'll update it if any types, you know, if anything changes.
Right.
Like in the last 6 years I've been in office, the age that the state wants for autopsies has moved from 55 to 50. And it's only because, you know, of environmental impacts and things like that, of heart disease and stuff. So there has been some changes that might need to be done, and Magistrate Dive, I've worked on, you know, if there are any upcoming changes that I'll make sure that everybody know about.
Okay. Thank you, sir.
We're all getting autopsies, by the way. Everybody else.
Well, you say you're gonna give me one of those books for some reason?
All right, this is a good brochure, David. Okay. I'll just make one cheap shot here. You got Oldham County Coroner on the cover
redundant.
there twice.
I've been looking at it so much lately, I did see
Yeah, I
that,
know.
and I'm like, oh.
You're right, but it's good.
But those little
I
things like
left
that.
that one for you, Judge.
Pardon?
I left that one for you.
Yeah, okay, thank you. All right, motion on floor to approve this. All in favor, please say aye.
Aye.
All right, thank you.
Thank you.
And I know
Thank you.
that pressing thing you got to go to is probably around your kitchen table, right?
No, it's grandchildren.
Oh, grandchildren, all right.
Thank you
Well,
very much.
those are very important. Okay, thank you, David. All right, next one, KYTC contract for Mattingly Old LaGrange Road Trail Project.
Thank you, Judge. Jim Urban, Director of Planning and Development Services, and Belinda Demas, who's a planner. She'll give you the details of this. But I realize every time we come up here, sometimes you don't even know what the project is that we're talking about. So just real quickly, to refresh your memory, this brochure, the first slide, is from actually about 1999 or the year 2000, where we did a interurban greenway trail study. And we're talking about connecting with paths and trails throughout the county. So going way back to about the year 2000, we were already thinking about connecting trails. When the Parks Master Plan was updated, this slide is from 2008. Branster Carroll put in some other components and phasing for that Greenway Trail. So back in 2008, Parks Master Plan was adopted. They were talking about the Greenway Trail. As you know, parts of it have been done. So this map with the red actually depicts a little bit of that, or most of it, with some additions. If you look up here, we didn't anticipate the Ernie Harris Parkway being constructed, and there's a 10-foot wide shared use path along Ernie Harris Parkway. So that's a different component of that interurban trail that we were talking about, and it's completed. The trail from LaGrange along Commerce Parkway has been done probably since I think about 2008. And then we're using the Old LaGrange Road instead of the interurban trail to connect to Crestwood and Pee Wee Valley. And if you remember, back in about 2012, the pedestrian bridge over I-71 was created. What we're working on currently is a segment of that trail. We call it the 329 bypass and Old LaGrange Trail component. There isn't currently a sidewalk where McDonald's is at Kentucky 146 that connects with Old LaGrange Road. So we've done the design for that, and we're in getting ready to start the right-of-way phase, and that will go along what we call the big three attractions on Old LaGrange Road, Third Turn Brewery, the Distillery, and Udell Gardens to Camden Lane. I'm going to skip over this project for a second. A next piece that will happen when the 393 project goes under the railroad tracks, there will be a 10-foot shared use path along that, and it will connect to Windemore Park. So what we're proposing today, and what Belinda is going to talk about in terms of allowing the judge to sign the contract in the agreement with KYTC, is on Mattingly Road. The Commerce Parkway extension from 393 to Mattingly includes this 10-foot wide shared use path. So it extends what's already on Commerce Parkway all the way to Mattingly. When it terminates at Mattingly, there isn't a sidewalk going up, and this is Mattingly Road. And then when you get to the top, this is just a picture. I could have put a whole bunch more pictures in here, but Old LaGrange Road, so from Kentucky 146 to the pedestrian bridge, doesn't have any facilities to continue that trail. So with that, I'm going to turn it over to Belinda to talk about the particulars of what we're asking fiscal court to consider.
So what's on the agenda is an agreement between fiscal court and the Kentucky Transportation Cabinet authorizing $199,800 in federal funds for the design phase of this trail section. And the section will connect with what was recently built as part of the Commerce Parkway extension, as Jim mentioned, and it's going to run to the pedestrian bridge over I-71 at exit 18 to the south, and then to the north it's going to meet up with Kentucky 146.
Exit 17.
17. Oh, I said 18, didn't I? Okay. So, sorry about that, but yeah. And so we're asking fiscal court to allow Judge Vogel to sign the agreement. There is a local match because it is federal funds. So for the $199,800 in federal funds, the local match will be $49,950.
Judge, I'll make the motion that you sign the agreement.
Second.
Okay, things move along at 5:30 here, don't they?
Fans are off.
Okay, we got a motion on the floor in a second. Any further discussion? Magistrate Howes.
What's the anticipated cost of the project, the total cost of the project?
So
199,
for all
800.
the phases?
No,
Just for the, so if we approve this today and do the design phase, are we going to build this phase next?
Well,
Or is
the
the
design phase is the first phase, and then there's right-of-way utilities and then construction. So the total cost of the project is $1,125,000, of which we would be contributing 20%, or $225,000 over those 4 phases.
right, but I think you're just talking about this phase, right?
No, I'm talking about the total project.
The whole thing.
Yes, about the
Okay,
total.
Magistrate Hawkins.
I wanted to make the statement that I remember when we were having community meetings regarding the future land use of the county and how that was going to change. One of the biggest things that we heard from the public during those public meetings, and I think I attended all of them because they were in all different parts of the county, the biggest thing I remember coming out of that was how constituents wanted connectivity. And so I'm in favor of this, and I'm glad that we're kind of moving forward to get it going now.
Yeah, I mean, we've, again, started back in roughly about the year 2000 planning, and we've been doing segments all along, and it really is. You could get on a bicycle at 53 and Blakemore Lane on the Ernie Harris Parkway, and you can ride, really, you'd be able to ride all the way to Pee Wee Valley. And
Or
beyond.
run without having to be in the street.
That's correct.
And I think it promotes health in our county, and I support this.
Judge.
Magistrate Dye.
Belinda, how much of this 225,000 county's part, how much of that can we get in some sort of an in-kind contribution on that?
Well, we could possibly ask once we have an alignment, a selected alignment, because they're going to give us choices. Once you select an alignment, then you go into a right-of-way phase. And there's potential that if someone wanted to donate right-of-way, we could use that value as a match. But of course, we don't know what the parcels will be or if anybody would be willing to donate at this point. But if they were, we could use that donation
And
as match.
At what point in time in the future would you think that would come about?
Well, it looks like about 2 years.
2 years?
Yeah, about a year to get through design. And then once we have a design alignment, then we would go to the right-of-way phase.
Okay, well, Judge, you get ready for some arm twisting in about 24 months.
Magistrate Jeffries.
Just one quick thing. Serving on the Finance Committee, I would assume that these numbers will come through finance so we can add them to the budget for the next 2 years.
These are in the budget. I forgot to mention that. Yeah, this project is already in the budget. We don't bring anything forward that isn't already in the budget.
For the whole cost.
Well, we do prepare a capital budget, and actually, we used to do a 5-year capital budget. It's a little different now, but.
Right, well, because you all only budget a fiscal year at a time.
Correct.
So
True.
the design phase is in there.
Right,
yes.
that's what I'm saying. So
Yes.
we've got, it's budgeted for the first 22,000, whatever it is, our match, but then the next year and the year after, that's not in the budget yet.
Correct.
Okay.
Because you haven't prepared that budget
That's
yet.
right. That's right.
Yes, but we always update that and put that during the budget preparation period.
Thank you. Okay.
All right,
Matt,
we've
back
got a
up.
motion on the floor and discussion here to move forward on this. Seeing no further questions, all in favor, please say aye.
Aye.
Anyone opposed?
Aye.
Okay, Magistrate Tice opposes that, all right. Motion carries 8-1, thank you.
Thank you.
All right.
What is wrong with Ty?
Now we're on to committee reports and recommendations here. I guess Jim Silliman has these.
Jim Silliman, Oldham County Engineer, 100 West Jefferson Street. And actually, Magistrate Hound's mentioned when we opened the bids for paving, potentially bringing those back for approval. If now's a good time for you, I'd like to make a recommendation for the
Okay,
paving
go
bids.
ahead. I think we can-
So Libs Paving was the low responsible bidder with a bid of $1,194,207.50. Did review these bids. I'm sorry. Oh, yes, I'm sorry. This is for Group 1 paving for the county roads, because Pewee Valley will award their own. So,
Oh, okay.
thank you, Tara.
All right, how much was that, a million?
$1,194,207.50. Again, they were the low responsible bidder. They used all the proper documentation. They've done multiple county projects of this scope. And so after reviewing the bids with County Treasurer and Road Superintendent Ben Kimbler, I'd like to recommend that the Fiscal Court recommend or award this project to Libs Paving.
Measure Jeffries?
Judge, I will move that we accept the low bid from Libs Paving Company for Group 1 Fall 2023 county paving of $1,194,270.50.
Second.
Seven.
207.50.
I'm sorry. Oh, I said, I wrote it down wrong. It must 207.50, sorry.
All right, and who seconded, somebody seconded that?
I did, sir.
Okay, all right, all in favor, please say aye.
Aye.
I have a question, but it won't affect the motion.
Okay, what's your question?
First is that where does that fall in line with what we budgeted for the fall paving?
So I believe, well, it's within probably 10%. Was a little bit higher, but there's a lot of culvert work that's involved in this project. And based on depth and conditions, that culvert work tends to vary anyway. As far as the annual paving, we have, I believe, $2,550,000 for the annual budget, which will pick up the remainder with spring paving.
When do we anticipate this to be done? Is this going to be a carryover like we had last year?
Yeah, it's intended to be completed for the fiscal year. It's named Fall 2023 paving because when we're bidding it, but they have until the end of the year. Now, likely what they'll do is because there's a significant amount of culvert work, they could do that through the winter. But it's a fiscal year completion.
Okay, we got kind of jammed up last year, if I remember right, when we had fall paving continued into spring paving, and then we were approving the same paving contractor to do the fall and the spring paving. My issue, I think we got to get these bids out earlier. And because if there's a change in the cost of petroleum, we're going to get smacked twice. We're going to get smacked on fall paving, and we're going to get smacked on spring paving.
Maybe. With the second one, your chances are lower because there's less time for that potential for the increase. The first one,
I know, but you've given them more time, allowing fall paving. I just would like to see the paving contract. The paving, call it fall paving, needs to be done by November 15th.
Well,
we would work next year to get them out sooner.
We're not going to set a deadline here
I know.
today.
We can't. I mean, it's the 1st of October to tell them they've got 45 days to get maybe 9 days.
That wasn't
worth
part
work
of the
done. It's not
contract.
fair.
You're saying in the future.
I'm saying in the future, yes. Sorry, that wasn't clear. I meant in the future, not currently. It's not fair to award on October the 3rd and tell them they got to be done by November the 15th. I mean, that's not fair.
Right. You also have the benefit, there's the likelihood that petroleum prices go down. We've benefited numerous times on that reduction, so it could work either way.
Okay, well, let's go on with these other ones here. Let's go by with these bond releases now, I think. We need to
Did
do
we-
that.
Yes, it was approved.
We vote?
Yes,
We did vote.
Yeah, we
Pewee
voted.
Valley?
Yeah, we did. The magistrate started talking.
Okay, road committee recommendations here. Jim?
So the first recommendation for a surety release you see is for the Humane Society.
Excuse me for interrupting, but we don't do Pewee Valley, that's right.
No, Pewee will do their own. That's correct.
Sorry about that. I think I've done that twice.
That's correct. Humane Society of Oldham County, they've completed their project that's located on Interior Way. We've inspected that, and it's completed in accordance with the plans and that were approved and the subdivision regulations. So I'm recommending that Fiscal Court release the surety that was, it was a check, so it would go back to them in the amount of $26,500.
I'll make that motion.
Second.
All in favor, please say aye.
Aye.
Motion carries.
Okay, secondly, we have the release for the surety for Heather Ridge, Section 2, and this is an erosion control surety. Similarly, they have completed, or we've completed our inspections, they've completed their work in accordance with the approved plans and subdivision regulations, and I recommend that Oldham County Fiscal Court release the surety, which was a check, in the amount of $67,800.
Motion to approve.
Second.
All in favor, please say aye.
Aye.
Will that release their money for that pond money that we've been holding on them, or?
No, Heather Ridge has 4 sections.
That's all.
Some of the performance have been released, some of the erosion, but not all, and the pond bond has not been released, correct, which is in Section 1.
Thank you.
You're welcome. Next is Commons of Cedar Point, Section 2, and this is a performance bond, and this will have 2 components because it does have roads to take into the county maintenance system. So the first is, there were 2 bonds or 2 forms of surety placed on this. One was a bond in the amount of $21,840. The other, it was supplemented with a check in the amount of $12,432. And this again is for the performance surety for Commons of Cedar Point, Section 2. And I'm recommending Oldham County Fiscal Court release this surety.
Make that motion.
Second.
All right, discussion. All in favor, please say aye.
Aye.
Motion carries.
So the second component of this is the roads within Cedar Point, Commons of Cedar Point, Section 2. I recommend that they be taken into the Oldham County road maintenance system, and it's Scarlet Oak Lane and 2 loop eyebrows consisting of about 1,600 feet or 0.3 miles.
Make that motion.
Second.
Second, all right. Any objection to bringing these in? If not, all in favor, please say aye.
Aye.
The last one I have for you is Clifford Lane improvements. This is associated with the Clifford Lane development in the city of LaGrange. The road itself was widened and sidewalks are added. This is outside the development itself, but there was a performance bond posted for that. The amount of that bond was $71,900. And this didn't go through road committee. Came after our last meeting. However, it's again within the city of LaGrange, and I did coordinate this inspection with the Director of Public Works, Corey Rusnick.
All right. Is there a motion here?
Motion to approve.
Second. All right.
Looks nice.
All in favor, please say aye.
Aye.
Motion carries. Thank you.
You're welcome. Just for clarity, even though that was a bond, a performance bond, and it has to do with roads, it was an improvement of an existing road, so there's no additional roads to be taken in. All
right.
Thank you.
All right. Item E under committee reports, recommendations, Grants Committee. Manager Logston.
Yes, sir. Before you all have had a chance to look over the recommendations from the Human Resources on the grants for this year. I'll let Rebecca answer any questions y'all have, but this is our recommendation. The list of the awards are in front of you, so I'd like to make a recommendation that we accept these grants in front of us.
Second.
Moved and seconded. All right. Any discussion on them? Hearing none, all in favor, please say aye.
Aye.
Anyone opposed? Motion carries.
You
Thank
know,
you.
Rebecca, it ceases to amaze me.
I know.
It should.
You put in a long afternoon for a short
We wore 'em
appearance.
Thank you, Becky.
Sorry, Rebecca, you didn't get it all.
All right, now we're down to, let's say, item G, personnel here, police appointment.
Well, Judge, we have 2 promotions at the police department. We have 2 sergeants promotions, actually. One is Gerald Giles at $42.45 per hour, and that will be effective tomorrow. And the other is Detective Jackie Davidson at $39.62 base hourly rate, also effective tomorrow.
Judge, I'll make
Do
the
you want these
motion, we
in 2 separate
approve
motions?
the raise to these 2 fine gentlemen.
I don't know.
Is
What'd
Jackie
you
a
say?
man?
You made-
I made the motion
Okay.
that we approve the raises to these two officers.
Do we have a second here?
Second.
Yes.
Questions? Somebody have?
What's the second officer's name?
Jackie Davidson.
Davidson. All right, thank you.
So I think the motion is, one's
being-
officer, one's detective.
They're both being
Magistrate, like it's-
promoted to sergeant.
They're both being promoted to sergeant. So one's officer, you said these two officers, one's officer, one's detective. Still both officers.
Right.
So
Well,
two sergeants.
they're both police
Okay.
officers. you know.
Well, the initial one was these two gentlemen, and I don't know if Jackie's a man or a woman.
don't either.
So officers is more appropriate if they are both in fact officers.
They're both men.
They are?
They're both
Okay.
men, yeah.
They're both men.
Okay.
All right, we'll get a motion second.
Wanna
All
be
in
correct?
favor, please say aye.
Aye.
Thank you. Okay. Time now, there's no one here for public comment, I don't believe, unless it's the sheriff who wants to make a public comment back there, okay? All right, okay. Oh, he will? Okay.
Oh, he will make a comment.
Okay. All right, now.
Put you on the clock.
Put him on for a minute.
He wants a cushion on that seat back there.
You're gonna
That's
set the
all
clock
good. No,
for him?
I would take a cushion on that seat and hire armrest, but it's October 3rd. By now, a bunch of you have already gotten your tax bills, and I'll be kind enough to give you a 2% discount if you pay it by the end of October. So just wanted the residents to know tax bills are out. If you haven't received one, probably by the 15th, you need to contact our office, and we'll check on that for you. So.
I haven't looked at mine, but somebody walked in here and asked me today why the homestead exemption did not appear on his tax bill. Do you know?
It was on mine. I paid mine
Was?
today. You got my money, buddy.
Okay.
And thank you, and I'll give you the 2% discount.
All right.
Hey, that's why I got it in there, because I want to get in that discount column before the rest of these guys do.
If they're due the homestead discount, have them call PVAs, and they'll apply that for them and give them a new bill. So.
Okay.
You know that's only good for 10 years, Judge. They take it off when you turn 75.
Oh, well, thank you. All right.
That is not accurate. Stick to what I said.
All right. Thank you for public comment. All right, now, I'd like to make a motion. We go into executive session here. We have two things to discuss. One is the deliberation under KRS 61.810 subsection B, deliberations on the future acquisition or sale of real estate by a public agency. And we will ask Kevin, of course, Kevin Nuss will be in there, and Stan Clark, I think, is going home. So, Barry, of course. And also then the second part has to do with the KRS 61.810 subsection F, discussion that might lead to appointment, discipline, appointment of an individual. Now we're going to stop right there. All right. Motion, please.
So moved.
Second.
Oh, I'll bet you $100 right now.
Not today, I pushed my deal.
There a motion, we go back into session?
So
please?
moved.
Second.
All in favor, please say aye.
Aye.
All right.
Judge,
Yes, sir.
I would, is it appropriate now for a motion?
Yes.
I would like to move that we allow you to pursue or
Negotiations. Pursue
The
negotiations.
purchase of a
Negotiate
negotiate
piece of
for a
property
piece of
in the
property.
Yes. Second.
All right. Moved and seconded that I be allowed to negotiate and to discuss a certain piece of property with an owner. All in favor, please say aye.
Aye.
Anyone opposed? Motion carries. Thank you. All right, we're at the end of the meeting here. We'll see if there's any final comments.
Judge, point of order, you all also adjourned to go talk about a personnel matter, and I
Oh, yeah.
believe you took no action on that.
Yeah, we took, correct, thank you. We took no action on that. All right, thank you. All right, Magistrate Likens, would you like to?
Four score and 7 years.
Start of this meeting.
This has been a long meeting. I wanted to, someone will mention this, we have the thing this Saturday, which is the J.D. Shelton as the headliner down at the Windemore Park. So it should be a fun event. I hope everyone comes out.
Great, thank you. Magistrate Tice.
Weather's supposed to be good. I have nothing today. Thank you, Jim.
Okay. Magistrate Woosley.
Judge, I just want to make sure we mentioned the burn ban that was put into effect. Are you going to mention that? Or?
Oh, you go ahead,
Okay.
that's fine.
Effective yesterday until further notice, countywide burn ban. I know this was mentioned earlier, but we have the household hazardous waste this Saturday from 9 to 3. It's at the road department on Quality Place. And then finally, tomorrow at 2:20, there's a nationwide emergency alert notification that'll be sent out on every cell phone, radio, and TV.
Turn your phone on.
Tomorrow, 2:20.
Okay, tomorrow at 2:20, don't be surprised you get a phone call.
Yes, sir. That's all I have.
Okay. Magistrate Jeffries.
Yes, a couple things. The main issue that I want to bring to everybody's attention is that out in my area on Highway 53, I guess it'd be south, would be the Kentucky Transportation Cabinet is advised motorists on the daily closure of Kentucky 53 scheduled to begin next week in Oldham County. Kentucky 53, LaGrange Road, will be closed from 7 a.m. to 6 p.m. beginning Monday, October 9th, through Saturday, October 14th, as crews work to replace the rails on the bridge over Floyd's Fork, mile point 1.9. And motorists should heed signage and seek an alternate route and adjust commute times to accommodate the closures. And I have been in contact with the director of Oldham County for their transportation to let them know, and I think they're working that around to be able to get students picked up and dropped off over there. But folks that are familiar with 53, when you come around the curve there by Hannah Road, it's the first real narrow bridge that you're going to cross there, and they're going to replace the railing on both sides of that bridge. So they have to. It's a narrow bridge, so they've got to close that in order to make that happen. So I posted it on my Facebook page, and a couple of folks have shared that. So just need to get that out so that folks won't be surprised. They put an LED sign up yesterday in Ballardsville alerting folks that that's going to happen starting the 9th, which is next Monday.
All right, great.
Let's
Thank
see,
you.
one other thing real quick. Let's see here. Yeah, that's all, because Freddy's out here at LaGrange is going to open, I think, on October 24th, and they're supposed to have a ribbon cutting towards the end of October, so I might put that on your calendar, but it looks like Freddy's is going to open on October 24th. So that's all I have,
All
sir.
right, great. Magistrate Hounds.
Magistrate Woosley took away some of my thunder on his announcements, but a couple other announcements. One is that most of the matchers, if not all the matchers, receive an email from the extension office about a survey called Serve You Kentucky, and the information's supposed to go out, or the survey's gone out. They've asked people to take it. It takes about 10 minutes to complete the survey. The URL is go.uky.edu/serveky. It takes about 10 minutes to do the survey. I did it last night, but they're looking to get as much feedback as they possibly can about what things are needed in Oldham County. it's a pretty simple survey. The other thing I have is that we did that last year. We're going to do our Wear Pink again on our next meeting, which would be the 17th, if my math is correct. I think that Magistrate Logson went out and bought a shirt and tie and socks and everything for last year, so he probably wear that same outfit again this year. Probably the last time he wore it. The other thing is that, what's that? Could have been. Also, too, I know we did the grants today, and there's a lot of worthwhile causes on those grants. Hopefully that those folks will put that money to the best use possible. But one of the things is, and it talks about it in this survey, is food insecurities. And one of the things we did last year, and I got a ton of positive comments, and I think we ought to try to do it again this year, is to do a county food drive. If you remember last year, we had this whole thing lined up with corn and green beans, and someone asked why we didn't have peas and carrots. I just bought corn and green beans. But anyway, I think that'd be kind of cool if the court were to approve to do that again. That was all done with employee dollars and cents. It wasn't tax dollars. But the folks at the different food banks were very appreciative of it and received a lot of positive comments from people. And now's the time to start thinking about doing that again. Thank you.
Pink shirts too.
All right, great. All right, thank you. That's right. Food insecurity is a scary thing for people that find themselves in that position. Magistrate Hawkins.
I think everything's been covered. We covered the October festival in the park with J.D. Shelburne. We've covered 53 closing, wearing pink. So that's all I had today, Judge.
All right, thank you. Magistrate Dye.
Nothing today, Judge.
All right, Magistrate Logston.
And I'm the last one. They took all my thunder.
Motion to, sorry, Joe.
Several things are mentioned. One thing that was not mentioned, Saturday is going to be a busy day in Oldham County with the hazardous waste collection and with the J.D. Shelburne concert at Wendell Park. But from the morning, from 9 to 1 at City Place, Baptist Health and High Point have a healthy living program going on there, interactive health fair experience. So, encourage people to show up for that as well. So, if you happen to be here, and there's no one left in our auditorium here, even the sheriff has run out of gas and stepped into the hall here. No, but if you happen to be here 4 hours ago, you heard that Kroger is opening November 1st in Oldham County. So we're excited about that and looking forward to the opening of a brand new Kroger store, the first one they've opened in this region in the last 15 years. So we're proud to have that accomplishment come to our county. With that, wish everybody a happy day, and is there a motion to adjourn?
So moved.
Second.
We're adjourned.